Welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we make sense of the law one bite at a time. Whether it's live trials or splashy legal headlines, we are here for the facts in the law and no nonsense. Well, unless it comes from our furry four-legged friends, of course. Here is where you bring your unique perspective to agree or disagree with other people, but please, always in a way that's civil and productive. After all, we're here to get to the bottom of the truth with a capital T, and the best way to do that, of course, is with healthy dialogue. So, if that's what you're looking for, jump on in. We would love to have you. Let's get started. Hello. Happy Thursday. I had to double check it as I was saying. Happy Thursday. Hope you guys are having a good one. Good morning, good afternoon, good evening. Welcome from Holmes. Welcome from Indy. I'm sure at some point Mabby is also going to show up. Astra never shows up because she's always hiding. But anyway, so okay, we've got a recap today. I wanted to try doing this one live because, well, number one, I'm a little bit. That's Holmes's tail. I've been a little bit behind on this one, and I wanted to try to get this done before there's a verdict. I don't know; it might happen while we're live, but we will see. We will see. Meanwhile, Holmes is going to drive me nuts with his tail over here. What are you doing, buddy? What are you doing? Okay. Anyway, okay. So far what we've done with the James Crumbley trial. Again, it's Michigan versus James Crumbley. James Crumbley is the father of Ethan Crumbley. Ethan Crumbley is also known as the Oxford school shooter. So we have been covering this trial, not gavel to gavel like we did with the Hannah Gutierrez Reed trial, but I wanted to do recaps. I wanted to live stream some things here and there. And this trial has just been so fast. It ended so quickly. A 5-day trial. I mean, part of that, of course, is the fact that the defense didn't really put on a case. They put on one witness, and that's about it. There were some that they didn't even cross-examine that were some of the state's witnesses. But other than that, I mean, it's been a pretty streamlined trial, which is like really not unheard of. But you know, we've gotten so used to seeing some trials just sort of drag on, but this one really has not gone on any further than it really in some ways needs to. So anyway, so I hope that you guys managed to catch the live stream that I did first for the opening statements, and then the video that I uploaded yesterday for the recap for days 1 through 3. It was a long video, but I really wanted to get all of the relevant points that were being put across by both sides, right? Both, you know, some points that were made on cross-examination were important to make. Whether they were points that the jury is going to, you know, really give a lot of weight or not is another thing. But they were important points that were made. And so far, I will say, before we get into the testimony from day 4 and day 5, so far this trial, you know, my impression overall is that the attorneys on both sides were competent. Like there's really, I remember I didn't follow the Jennifer Crumbley trial as closely. But I do remember there being a lot about the lawyering involved, a lot about the speaking objections. There have been speaking objections in this trial as well, but they haven't gotten out of hand like we saw in the Hannah Gutierrez Reed trial, right? We learned we needed sidebars, not snide bars, right? So anyway, so there haven't been really too many snide bars or really any snide bars in this case, but there have been some speaking objections, but they have kept them to a minimum, relatively speaking. Maybe it's just coming out of the Hannah Gutierrez retrial that, like, you know, like my impression is like skewed because of that experience, that very recent experience, right? But maybe not. Overall, my impression is it's been good. So, anyway, okay. So that's days 1 through 3, you know, in a nutshell. I've already talked about it. Not going to rehash any of that. Let's get into day 4. It should be a lot faster to go through the testimony for days 4 and 5 because, well, first of all, there's only 2 days as opposed to 3 days. But also because a lot of this was just very simple stuff to get through. The simple stuff that they wanted to get across. And really, like, for the most part, factually speaking, there wasn't that much that was new. Like, there already was an indication about the fact that James and Jennifer Crumbley were on the run, right? There's this allegation by the prosecution that they were on the run. The defense says no, they weren't on the run. They were given advice of counsel, to go someplace else because they were getting death threats. But so most of day 4 is about them being allegedly on the run. Okay. So anyway, but I will say the end of day 4 is, when the state is putting on, well, almost their last witnesses, because they decide to bring up, they decided to recall one witness on day 5. But aside from that, they basically put the end of their case in chief in the end of day 4. They do have a very heavy emotional end to it, which I think was very successful. Okay, we'll get into it more as we get into it. So let's start with, let's see here. I've got a presentation. Okay. All right. And I don't know why this shifted over. Oh, come on. Don't do this to me. Okay. Okay. So day 4 started with the witness number 10 for the state. And this was Detective Adam Stoyek. So that's who's on the screen here. The main purpose of calling him was to introduce photos of the search of the Crumbley home. Not so much focusing on so much like firearms and stuff, but the overall, like, what was going on at the home. Taylor M, thanks so much for the super chat. I really like the defense attorney's closing. She got them involved. Come up with your own reasonable doubt. What would I say? Interesting. We're going to get to that because we are going to go through the actual closing arguments. We're going to watch them and comment on them, and all that kind of stuff. So we will get to that soon. So thank you so much. Looking forward to that for sure. All right. So once again, Detective Adam Stoyek, that's who you see on the screen. So he searched the home when they obtained a warrant, and then they got the guns. They searched it twice. First on November 30th, 2021, and then on December, when was that? December 2nd, I think. I have it in my notes here somewhere. One of the things that was really, really interesting was, well, first let's go through some of these photos here. So this is just the inside of the home, basic stuff. This is Ethan's room. At first, I was really struck by just how messy it was, but then I thought about it and I was like, well, a lot of teenagers are like that. And also he's very, clearly very disturbed teenager. So there's that part too. So there's the only posters on the wall were from target practice. These are also spent shell casings that were also in his room. This is a BB gun. It looks like an actual firearm, but it is a BB gun. So that was interesting. Also in his room was an empty bottle of whiskey. Also very interesting. On cross-examination, I will say that there were a number of things that the defense attorney did do, which was talking about, these various things of you don't know how that got there, right? You don't know exactly what happened with that thing. You just found that in the place where you found it, right? Okay, sure. And so this was one of those that she was like, well, you don't know, what happened with this bottle here, right? Or who put it there. Yeah, but it still looks pretty damaging. So then there's a gun case in the master bedroom, nothing in it. It had been open when they found it. I think that's ammunition next to it. This is also the gun safe, where they actually, one correction that I do have to make for my prior recap was I said that I had thought that there was only one gun in the safe. The other two of the 3 guns were in the gun safe. However, interesting point about the gun safe is that the gun safe had a code. So that's how they opened it, which the code for the safe apparently was 000. And when the state asked the witness, do you happen to know what the default code is for this kind of a gun safe? And he was like, yeah, it's 000. So in other words, it really wasn't that, like, it was secure. Yes. Okay. Technically these guns were in the safe. And who knows how much Ethan knew as to like what the default was and if his parents had changed it. Who knows if he ever tried to get in there or not. But the fact that it was still 000 when they found it, it's to me, that's just wild. That's just wild. Okay. So moving on down. So this is like magazines and ammunition that were found with the gun safe. So those are the 2 firearms that were in the safe. This is the kitchen island. You can see the circle here they were highlighting that because inside the cupboard there was where they found another case. You can see that case right there. That was for one of the other firearms that the parents had. There's nothing in it, however, other than the cable lock, which was for the 6-hour. So it seems like, this at first was alarming to me, but then I thought about the fact that, okay, but the Kel-Tec, which is what this case was for, was found in the safe. So that, it was in the safe along with the Derringer. Those 2 were technically locked away, although with a code that was the default code. Okay, so that is, let me see if there's anything else that I missed here for this particular witness. Okay, they had also mentioned a journal that Ethan wrote in, which is something that has been sort of echoed throughout trial. And every single time it comes up, the defense attorney always comes on cross-examination saying, you don't know if the defendant ever, saw anything or, was actually familiar with the substance of the journal itself, right? Even if when he referenced it, for example, when he referenced it in front of the dean of students and the guidance counselor. And so when they did on cross-examination, she asked them like, okay, so he mentioned it, but you don't know, he didn't describe any details about it, right? He didn't describe the color or the texture or, anything detailed about it. Okay, no. So you don't really know if he's familiar with it other than the fact that it exists, right? No. Okay, fine. So she did that here. And I mentioned this in the prior recap, and this turns out to be quite true by the end of day 4, that I had this feeling that the reason she was doing that was to lay a foundation, basically to try to prime the jury for thinking, okay, whatever it is that's coming out in this journal is going to be really, really, really bad. And so she needed to make sure that the jury understood, we don't necessarily know that James had any kind of access to it, that he knew what was being written in there. So, and then, she also cross-examined this witness also on, some similar stuff. You don't know how that thing got there. Like I mentioned before, you don't know how that whiskey bottle got there. You don't know how, this other thing got over there. So, she really tried her best to try to minimize this stuff. But in my opinion, it still was, overall fairly helpful to the state. Okay. So next witness was the state's 11th witness, which was Sergeant David Hendrick. Now, he was the fugitive. He was part of the fugitive apprehension team for Oakland County Sheriff's Office. So the purpose of his testimony, and basically almost everybody else from here on out in day 4, was basically to detail how they hunted down and apprehended the Crumbley parents. Like I said before, there's this whole allegation by the state that they had this consciousness of guilt, right? That they ran away because they knew what was coming. And so the defense is really trying to rebut that, saying, no, they were just hiding because of death threats. We'll see. Let me know what you guys think as to whether they were running away from the police or trying to hide from death threats, because the state definitely tries to go pretty hard on day 4 to convince the jury on their side. So like I said, so this witness here, he worked to locate the defendant and his wife when they went missing. He said he went through the whole process about how they went through family and friends and neighbors. They would try to get a tip here, a tip there. They would go to one hotel, then find out that the Crumbleys had already checked out of that hotel. I mean, this is like, from the narration of it, it almost sounds like someone has been watching too much Reacher, right? It's just like, it's just interesting how they're going from one place to another. And the state really wants, like I said, the state really wants the jury to come away from with all of these details thinking these aren't people that are just trying to get away from death threats. These are people that are like trying to evade the police. So like I said, it's interesting to see if people will have different perspectives. So, he says that they were using social media, they were using, other family contacts. They were trying to contact their attorneys. That was like the first people that they went to was the Crumbly's attorneys. And so, and that's the thing that kind of got me personally, is the fact that they went to the attorneys. I would have thought that if the Crumbleys had left on advice of counsel, I would have thought that the advice also would have been, if the police are looking for you, don't hide from them. Don't run away from them, because it's only going to make things worse. Now, that's what I would think that the attorneys would have advised. I don't necessarily know that the attorneys would have advised. It is always entirely possible that attorneys can give terrible advice too. And I don't know. I mean, so apparently the attorney who's defending James Crumbley at the trial was not one of the attorneys that was giving counsel to the Crumbleys before all of this went down, or as all of this went down. So anyhow, they've got two vehicles that they start tracking. Eventually they start tracking the other one. Then they start getting they get a tip that someone had seen their other vehicle in an outdoor parking lot just outside a 3-story industrial building. And so this is the Detroit Police Department got this tip. They shared it with them. And then basically he describes, okay, so then we end up going into this industrial building. The plan is to go floor by floor. On the first floor, that's where we found the Crumbleys. Okay, so that's the story that we get from him. And I can't remember if there's other. Oh yeah, so that's the 3-story building. So definitely looks pretty industrial. All right, next witness. Oh, you know what? Before we get there, a little bit about cross-examination here. One thing that was very interesting that the defense did point out is that, okay, so there's all of this about the Crumbleys being on the run, but on December 12th, 2021, that was when they started the search for the Crumbleys, and that's when this witness started to get involved. The defense attorney did point out that this was all before the Crumbleys were charged. And so, she's basically making this point of like, okay, how could they have been absconding if they weren't yet charged? And so, but the point of this witness and a couple other witnesses is that, okay, but we were looking to arrest them kind of concurrently while charging them. And then we found that they were missing. And then we found that we just couldn't find them. And we were, trying to hunt them down. And so, but the defense attorney did get him to admit that, there was nothing suggesting previously that the Crumbleys were a flight risk. There was nothing that he didn't know if the Crumbleys knew that they were charged. And also that the hotel that they had stayed in and that they had just checked out of was in Jennifer Crumbly's name. So, she wasn't exactly using some kind of an alias. She was using her own name. So, those are some points that are in favor of the defense. We'll see how it all shakes out in the end, though. All right. Next witness now. Okay, so this guy, so this is Luke Kirtley. He's the state's 12th witness. Now, he is clearly not law enforcement, right? He definitely has a very hipstery vibe to him, and he definitely had a hipstery vibe to him during his testimony. And as it turns out, he's the owner of coffee house. Let me see here. Coffee House Coffee Company. So they roast and import coffee in Detroit. They have like one cafe somewhere around Detroit. And so they've, yeah, like I said, they've got one one cafe in around somewhere around in Detroit, but this particular location that he's testifying about does not. It's like they're renting out like 3,000 square feet of this one industrial building, um, which they occupy, and so that's basically where they do a lot of coffee roasting. So, as you can imagine, all of this kind of ties into what we've been talking about so far. He's the guy that actually spotted the car in the parking lot just outside the industrial building. And he said that because he's a car enthusiast, he had just seen some kind of a post on Facebook about, them basically being wanted and some details about the car. He kind of put two and two together, and so called 911 and basically informed them, hey, these people are here. It looks like, he noticed that there was one person that was kind of crouched next to the car at one point. He said that they had like a blue plaid like jacket, and it was, the hood was up so he couldn't really see who it was exactly. But he did say that the police then came and they were arrested. So that's basically it. I mean, it kind of goes on for a little bit, but in the cross-examination, the defense attorney was like, okay, but the person that you saw out in the parking lot, they didn't chase you. They didn't threaten you, which is like, okay, like we wouldn't really expect that to happen anyway. But yeah, that's basically this guy in a nutshell. We can really keep it super simple with him. Next witness was Officer David Metzke. And basically the purpose of bringing him in was to show body cam footage showing the actual arrest inside the industrial building or the commercial tenants building, right? Because one of the things that the prior witness testified to is that, there's a lot of businesses that operate out of there, but none of them are like vendor businesses. There's no like cafes or anything like that for like the general public to come into. So, these are people that like generally work in this building, and just, they don't really operate at night. There's the lease says that you can't be sleeping there overnight, that kind of thing. So this officer, David Metzke, he said that he responded to a 911 call, placing the parents at the building. And so by the time he got there, it was after midnight, December 4th, 2021, and it was around an hour, or it was around 1:34 a.m. So all right, here I will show some stills from the body cam footage. So once again, that's the building. And it's kind of maybe a little bit hard to see here, but this is the Crumbleys on a mattress. There's like this table next to them. And then there's another shot. This is of obviously James Crumbley. And so you can see that plaid blue jacket that was identified by the previous witness. And so that's another shot. And then there's Jennifer Crumbley, and she's been arrested. And this is like, it looks like it's basically an art gallery. The state was referring to this as a warehouse, but it's not exactly a warehouse. It's more of an art gallery. So that's basically that witness. Number 14. So state's witness number 14 is William Creer. That's this guy right here. So the purpose of his testimony was basically to introduce photos of the scene after their apprehension. He basically went in, they had a search warrant. He went in, took photos, all this kind of thing. And let's see here. I think I saw a question. Sorry, I want to make sure that I am catching these. Okay. Okay, so so he just kind of went through some of the photos here, and none of them are particularly outrageous, but there are some things to take note of. So that's the car that was in the parking lot. It was noted that it was on the edge of the parking lot, not near the entrance. So clearly, like trying to stay away from people coming in and out of the building. He also said that, one of the things that they found there were cigarette butts kind of littered around the cars. You can kind of see that here, these little cigarettes. He said that there were like 14 of them. So then he was instructed to take photos inside suite 130. So this was on the first floor. They didn't have to go into the second or third floor because obviously they were going methodically and they were on the first floor. So this is more inside the art studio where they were kind of camping out for the night. And you can see here, this is the mattress that they were on. The police had taken out some drawers here that were right next to the mattress because they wanted to make sure that there weren't any sort of firearms or explosives nearby, to make sure that the place was clear and that it's safe. These are some brand new clothes that had been purchased that were found here. You can see there's a receipt here. These still have the tags on them, and this is like a shopping bag. So it's like you can see that they were either planning to be out for a bit. Maybe they were planning to not be seen, not be recognized. I don't know. This is food here, obviously. This and what was eventually testified to was that so to answer your question here, Debbie, so weird, so they got a trespassing charge as well. No. What happened was, I think that they didn't really give any details on like who owned this art studio or who was renting out this unit for the art studio. But I think this was some kind of a friend of one or both of them and was kind of allowing them to sort of stay there for the night. And because there was, and we'll get into it with the next witness, but there's some evidence that comes out that the person who has the studio went out and got them food, or one of the next witnesses. So you can see there's some Solo cups, there's some ginger ale, it looks like you've got some bananas here, some orange juice. So it looks like it's like easy stuff to eat and to not really stick around for too long is what it looks like. Here is a backpack that I think it was Jennifer Crumbley's. They opened it up and showed like the clothes that were inside. There were like undergarments and stuff. I'm not going to show that. This is a Stay America hotel key. So showing that they had been staying in a hotel. This is another one of these whiskey bottles, similar to the one that was found in Ethan's room. And then this was interesting because the witness said that, this became interesting to him to see, what was in this bin here. So he opened it up and saw that there was this tote bag or this purse. And it turns out it's got a bunch of stuff in it. To include, there's like some banking documents. There's also a like search warrant paperwork that was found in there. There's also a bunch of cash, which we can see up close. And they also, and well, I'll get into the cash in a second, but there's 4 phones here, one of which appears to be cracked. The witness said that none of them were on. None of them were turned on. All of them were turned off. So, also like really interesting that they have that many phones, because the defense has made a really big point to say, okay, well, their phones were seized. Their phones were seized by the state, right? So they needed some way to keep in contact with people, right? And so they said that's why they went to Walmart. They bought these track phones that are, pay as you go or what have you, so that, they don't have to have this huge expense of buying new phones, but they can still be in contact. But that also doesn't explain why they have four of them. I don't know how many phones they had before. Maybe for Jennifer, at least one of those is a work phone, perhaps. I don't know. But this is a little bit strange to have this many phones in this kind of a situation. Okay, now here's a cash. The witness said that they typically take out all of the bills and take photos of each and every one of them. So you can see a bunch of these. Now, I didn't catch how much money there was, and I don't think that they said. Something tells me it's probably not an outrageous amount of money. So, because if it was like $10,000 or something, they probably would have wanted to make that a point, because that definitely would sound like they're trying to go very far away. Okay. Now, before we do this, all right, cross-examination was basically inconsequential on that one, so we don't really need to get into that one. Okay, so this is the state's 15th witness. This is Detective Lieutenant Timothy Willis. Basically, the purpose of his testimony was he's like the main officer that's in charge of this case. He's with the Oakland County Sheriff's Office. And I mean, he basically he's been sitting at the prosecution's table throughout trial, like, because he's the main investigator here. He's able to do that. And so he's been able to witness all of it. And so basically he testified a little bit about like overall evidence gathering, but really the real meat and potatoes of his, or at least the most memorable part of his testimony, was the end of it. And we'll get into that in a second. So, but first, let's see here. I think, okay, before we get into that, I mean, so, he went through the fact that they bought track phones at Walmart, that they stayed at a Holiday Inn Express starting on November 30th, 2021. He showed, he talked about, or the state showed while he talked about bank withdrawals. So, all that cash that we saw. Then there was, some surveillance footage that they went through. And, the fact that he said, he talked about, sending officers to hospitals to ID victims. And he also mentioned, which was interesting, no one had mentioned this before, that there was, they got wind of the fact that Ethan had apparently made a video either on YouTube or maybe some other social media site. I think they mentioned YouTube, of him detonating a Molotov cocktail. So that became a concern. They weren't sure if maybe he had left some sort of explosives around the school, so they had to send someone to go and clear that away. So that was one bit of new information that we got here. But then he got into the backpack that Ethan had left behind in the bathroom right before he started the school shooting. And specifically, one of the things that they found was that he had also left behind in his backpack a journal. And this is the journal that has kind of been echoed throughout trial. And there's a reason why this is coming out last, because the state has really thought this through. Absolutely. Something that he testified about the journal is that it started on November 9th, 2021. That was the first entry date. And it didn't go from front to back. It went from back to front. Don't know why. Don't know what exactly that says. But, it did, although it only started on the 9th, it did reference some prior events. And then it stops about a quarter of the way through the pages in the journal. There were 22 entries, and he said that all of these entries reference a school shooting and his desire to execute a school shooting. So we're going to go through kind of quickly some of these journal entries, because I want to go through and I don't want to dwell on these too much, because they're really heavy and shocking. So of course, this is why the defense attorney was so adamant about making the jury understand, hey, defendant didn't know about these. We don't know that defendant knew about any of these. So I have zero help for my mental problems, and it's causing me to S up the effing school. And then here's another one. Page 5 of his journal. I want help, but my parents don't listen to me, so I can't get any help. That's not great for the defense. Even if the defendant didn't see this, it's not great for the defense. My parents won't listen to me about help or a therapist. Also not good for the defense. So we should be, I think, bound to get my my SD9VE soon, which they showed this. That's the model of this particular gun. Okay. Then there's this one. You can just read it, what it says on the page. And then page 17. All I need is my 9mm. I'm currently begging my dad for. I will have to find where my dad hid my 9mm before I can do this thing. And then here's another one. It's just each one goes goes on and on. How, he's talking about how, how a 9mm pistol is effective for doing this kind of thing. Bad stuff for the defense. This is just like, it's really, really heavy, shocking stuff. I'm about to do this thing and spend the rest of my life in prison. First off, I got it. It's an SP 2022 6-hour 9mm. And then here he shows a copy of the journal, or not a copy, the journal, to the jury. It was not admitted into evidence because the state was able to introduce these entries. There are apparently other entries that they were not able to introduce. And so I don't know if that's better or worse for the state or for the defense, but they were able to see it as a demonstrative in court. Now, after this, they also played the video again of the defendant going through the school, doing exactly what he says in the journal entries he's planning to do. The media was not able to see it or hear it, so we just basically watched the reaction of James Crumbley as he's like trying to emotionally keep it together as he's watching this, and everybody else in the courtroom is also watching it. Then after that, understandably, they go through all of the four victims who died. They go through, they say their name, they show their photo to the jury, they talk about their age, they talk about how they died. So this is just like absolutely heavy. On cross-examination, then, again, the defense attorney says, you don't know if the defendant was actually aware of some of these things. They also weren't charged yet when they stopped using their home, when they went someplace else. The journal, there aren't any dates for any other entry other than November 9th. So, this is, we don't really know. You don't know for sure, when he actually put those entries in, whether that's over time or even all in one day. And then she also points out that in one of the entries, he wrote that he needed to find where his dad hid the Kel-Tec, so one of the other firearms. So in other words, pointing out, okay, dad did do a good job of securing that firearm. Now, on redirect, though, let me mention this first on cross-examination. So on cross-examination, the defense attorney also said, okay, so you don't know that this journal that was found was, one that the defense attorney or that the defendant was actually aware of. So the witness was like, well, yeah, I am sure that he's aware of it because he referenced it to other people, with the guidance counselor and with the dean of students. And so he's like, I mean, yeah, he was aware of it. And so she's like, well, you don't know if maybe the shooter had multiple journals, and maybe he had one in his backpack and he kept one at home, and this kind of thing. And he was like, I mean, I guess not, but he's like, but like, I'm pretty sure that he knew about this journal. And so then on redirect, the state got up and was like, okay, so the defendant, when he referenced a journal to the guidance counselor and to the dean of students, did he reference more than one journal, or did he reference only one journal? And the witness was like, oh yeah, he referenced one journal. And then the state asked him if when they searched the house twice, they found a bunch of stuff. Did they find any other journals? No, they found only one. There's only one that was found. So, is there any indication, in any journal entry that the 6-hour was ever hidden or locked up? No. So that was a pretty strong finish for the state, and definitely a strong finish for the state on day 4. Day 5, there was only 2 witnesses who were called. There was one that was recalled for the state. That was witness number 9. So this is, hang on. This is the ATF agent, Brett Brandon, Special Agent Brett Brandon. from the ATF. So he came back really quick for like 3.5 minutes, came on. Um, and basically he came in to sort of shore up some stuff from the industrial complex incident when they were apprehended, right? So he basically came in to talk about the surveillance video that he had reviewed of the Crumbley parents going out into the parking lot and coming back. He just testified that, they would go out to the parking lot to smoke cigarettes, but they would never leave the premises. And then he says that there also was forensics indicating that the tenant of the art studio brought them food. And this, it seems like kind of a nothing burger, but it did have a purpose. And the purpose of it was to indicate to the jury that they were really trying to stay hidden. They weren't going out for food. They were asking someone else to go and get them food. They weren't leaving the premises. They were kind of sticking around this one area where there probably weren't going to be too many people. So that's basically what all of that was. And after that, the state rested. And one thing that was really interesting to me is that the defense did not move for a directed verdict, which was really, really interesting. They just blew right past that. It's a lot of attorneys will say well, first of all, it is best practice to do a directed verdict every time, even if you think that you might fail. But is it malpractice to not do so? There are some that would say that it probably is. But, here it just was very, very interesting to me, at least, that the defense attorney just blew right past that. So if you're not familiar, directed verdict is basically where the defense attorney gets up and says, Your Honor, now that the state has closed their case in chief, they have all of X, Y, and Z that they've put on. However, they're supposed to prove all of these elements. There's, this element or this element that they have not checked the box. They have not provided a single scintilla of evidence, right? A chinchilla of evidence, or a chinchilla of elephants, if you will. And so basically to say, like, and that's why, Your Honor, this case should be thrown out. It shouldn't even go to a jury. We shouldn't waste their time or waste the court's time. So, that's an argument that definitely would have failed in this case, for sure, in my opinion. However, I don't know that, yeah, I don't know. I mean, it definitely would have failed. It definitely would have failed. But, it was just it still was interesting that she didn't even make the case for it. Anyway, after this, the defense went to their case in chief, and they only had one witness, which was interesting. And that was, let's see here. That was Karen Crumbley, the defendant's sister, James's sister. So, the purpose of bringing her on, of course, is like, it should be fairly obvious, right? This is sympathy for the defendant. This is, she also had a little bit of a window into the family. So she, basically was going to be testifying to, like, there was no indication that Ethan was going to do the thing that he ended up doing. And so she basically testified to like two instances within the previous 6 months when she was with the Crumbley family, because she lives in Florida herself. But in April 2021, they came down to Florida because their mom, her mom and James's mom had died. And so they were there for last days and for the funeral and all that kind of stuff. And so, she said that there were no conversations with James about, being concerned about Ethan or there being some sort of an issue with Ethan. And then she says that in June of 2021, she actually went up to Michigan and stayed with James and with the family and for a few days and got to live with them for a bit. And the same thing, saw nothing concerning about Ethan. And it was nothing. There was nothing. There was no indication that there was any sort of trouble there with him, according to her testimony. But then on cross-examination, the state came in and was like, okay, but how much time have you been spending with the Crumbley family, right? April 2021, or the last time before the shooting that you were around Ethan or his dad is, and of course they don't refer to him as Ethan. They refer to him as the shooter. And I see that super chat. I'm going to answer that in just a second. That the last time before the shooting that she had been around these people was June 2021. So June to November, there's a few months for things to go awry, right? And then before that, the last time that she had seen them before June was April. So these are small snippets of time overall in the previous 6 months in which she had been around them. And so on top of that, the state was also like, okay, but you guys also aren't that close. And she's like, well, we're pretty close. And he was like, well, but not really, right? Because looking at your call logs, there's only been 3 actual phone calls between you guys in the last 6 months, I think. Or in 2021 overall, even though they had also called through like Facebook Messenger and like, that kind of stuff. There it was like max once a month, max. And that might be stretching it a bit from what the testimony was showing. She also did not know that the Crumbley parents had bought Ethan a weapon. So, that's a bit of a big detail that she wasn't aware of. So then, actually, before we do that, let's answer this. Taylor M, thanks for the super chat. Why do they refer to him as a shooter instead of his name, Ethan? So that is, I think it has to do with him having been a minor during all of this. And I think the defense probably wanted it because this was a stipulation that was outside of trial, before trial, that they came to. But I think the defense likes it because this is a way of kind of distancing the person who did the shooting from the defendant who's actually sitting in the courtroom. But I think it also has to do with his age, maintaining some anonymity for his name, him having been a minor, even though I believe he was charged as an adult. Okay, so then the big question is the defendant going to testify or not, right? Because he's got a Fifth Amendment right to not incriminate himself. He can choose to stay silent. And what he chose here was to remain silent. So unlike Jennifer, unlike his wife, he decided not to testify. And that probably is better because, if you were following the Jennifer Crumbley trial at all, you probably are aware that really backfired. There was a particular moment that people really, really hung on to very quickly, and understandably so, that where she was asked if you could go back in time, would you do anything different? And she said no, which is just, I understand that on the one hand, you don't want the defendant to be admitting guilt, but at the same time, you also don't want them sounding completely tone deaf when there are family members of the victims who have died in the room. So anyway, so here, this is, he's being questioned, as always happens with a criminal defendant. When they decide to testify or decide not to testify, either way, they go through a series of questions on the record in front of the judge, saying, you understand that you have a right to testify. You understand that you have a right not to testify. And and you are making this choice one way or another without any sort of pressure from anyone else. This is what you are deciding on your own. Okay, what is your decision? And so that's what he decided. He decided not to testify. So then defense rests, and that means we are up to the closing arguments. Okay. So let's turn to the closing arguments then. All right. Bringing up a new screen. Okay. Here we are. And before we do that, let me just make sure that I've got these questions answered here. Debbie Faison Cook, did the parents ever think that they were going to be charged? I don't know. I'm not sure. I'm not certain, because their behavior, in leaving right away on November 30th does make sense, that they might want to be like, trying to get away from people calling them and sending them social media DMs and all kinds of stuff. I can only imagine the kind of hate that they were receiving at the time. That I can understand, but it's the subsequent days, especially when at least their attorneys found out that they were being asked for by the police. So I don't know. I'm not certain if they ever thought that they were going to be charged. I think at the time that they gave the police interview, I don't think that they ever considered the possibility that they would be charged. That's my impression from that. Keely H, do you see any better arguments for James that might be more likely for an acquittal for him versus Jennifer? Well, it's hard for me to compare that to the Jennifer Crumbley case because, like I said, I don't have as detailed knowledge of what was presented in that case. I've got the highlights basically, but I don't have the details. But here it seems that, he can kind of play the aloof dad. There's, moms very often can't really play that sort of argument or that sort of role, although she was the main breadwinner in this case. So that's a little bit reversed. But, trying to make it look like he's just particularly thick, I suppose could help, but that still doesn't get the defense to where they want or need to be because there's still the reasonable person issue. Like even, when we're talking about criminal negligence, which is one of the elements here, we're talking about recklessness, which is that they knew or should have known that they were creating a risk in their conduct, right? And that they consciously disregarded that risk. So, knew or should have been, meaning that they can be compared to a reasonable person. And once we saw the testimony from Hopkins, the guidance counselor, and EJAC, the dean of students, it was a lot harder for the defense to argue there's no way that we could have seen this coming because there are other people that were kind of flagging this thing and flagging them specifically to the parents. So I think, they seemed to be distracted by other things in their life, but that doesn't necessarily, in this case especially, that doesn't necessarily let them off the hook. Sarah with a question. Why didn't they mention the journal as much in Jennifer's trial? The 3 witnesses that spoke about it this time did not do so in her trial. Is it because the dad appeared to care more than the mom? I think it's because the dad specifically referenced the journal in the guidance counselor meeting. The mom didn't reference it. So I think that, that right there is evidence that he knew that it existed. So you can have a stronger argument that he's got awareness of this. It's coming right from him unprompted. And so they don't quite have anything like that in the Jennifer Crumbley trial because she didn't make a similar sort of statement from what I understand. Correct me if I'm wrong if you guys watched that from gavel to gavel, but that was my impression. So I think that's why it couldn't come in as much as it could in this trial. Okay, let's get to the closing arguments here. Now remember before we do that, remember that with closing arguments, this is the sandwich, the back end of the sandwich to the opening statements, right? And the opening statements are all about establishing a framework, giving a roadmap for what they're going to see, making all these promises for what they're going to see, and the kind of conclusions that they might make as a result of seeing all of that. And so that's basically what the opening statement is supposed to do. Closing argument is when you take from all of these pieces that have been introduced at trial and you tie them up into a beautiful little bow and you package it well so that you are saying you're drawing from all of these pieces individually to say, not the evidence will show, but the evidence has shown. Now you have seen for yourself that XYZ happened. And now you can tell that, our argument that XYZ, ABC, all of these things did happen in the way that we said that they would. Or the jury's going to look at the one side and say, you made all these promises and you did not keep those promises. I did not see the things that you said I was going to see. So, either of these is possible. I've talked about a theme with opening statements. It's very helpful when there is a theme, something that can kind of be echoed again later on to sort of remind the jury of to sort of like remind the jury of what they were supposed to remember, what they're supposed to hold on to. So little phrases, little buzzwords that have been repeated are really, really, really helpful to that end. So this is one thing that I'm going to be looking for. I will tell you, I have watched a little bit of the state's closing argument. I have not watched all of it, and I haven't watched any of the defense's closing argument. So this is going to be a little bit fresh for me. I hope you guys aren't frustrated by me pausing and commenting and all this kind of stuff. But this is going to be kind of like my raw thoughts as we go as we go through this. So, all right, here we go. So this is, like I said, state's closing arguments, and I'm going to update I'm going to pin a comment in the chat, in the live chat, so that folks can see where we are when we are. And then also on replay, I'm going to be putting timestamps in this because I know it's going to end up being long. We're already almost an hour in. And so that's what we're going to do to kind of make things a little bit easier for folks. All right, let's get started. Oh, and also, as always, volume stuff. Let me know if there's an issue with balance and whatnot.
On November 30th of 2021.
Sorry, that is quiet. Oh my gosh, no wonder. Okay, I turned the volume way up.
Around 1 o'clock in the afternoon, Lieutenant Tim Willis doesn't remember exactly what happened immediately upon being informed that there's a possible shooter at the Oxford High School. Doesn't really remember who he called or how he got down in the elevator, but he remembers one thing. Whoever he called, the first thing the caller said was, "It's real." Doesn't really remember the details on how he got there that day. But he did tell you that of all the first responder scenes he's ever experienced in his 20 plus years of being in law enforcement, this was the largest and most serious by far. And the second, what didn't even come close. Ed Wagrowski, who is now works for the Secret Service, but was worked for the Sheriff's Office in the Computer Crimes Department, told you that he went so fast that he could barely keep his tires on the road. He told you that he will never forget the look on those kids' faces because they looked like zombies. He also told you that in that moment of crisis, he will never forget the looks on the parents' faces who were waiting desperately for their kid to get off those buses. Molly Darnell, a seasoned teacher who had years and years of training on what to do in an active shooter situation, she told you that even though she locked eyes with James Crumbley's son when he fired his SIG 9mm at her and hit her, she still couldn't believe she was shot. She told you that she didn't even put it together when she felt the warmth and burning on her arm. She didn't even trust herself to recognize a voice she'd known for over 20 years outside the door. And you heard from Chrissy Gibson Marshall, an assistant principal who had hours and hours of training on what to do in an active shooting situation. And what did she do? She ran towards the shooter. She ran towards the shooter. All the training, all the preparation, and she did the opposite of what she was trained to do and what she tells everybody else to do. Because she couldn't believe it. And even when she saw James Crumbley's son with that gun, she still couldn't believe it. But she wasn't going to leave because Tate needed her help. All four of these individuals, training for years and years and years, law enforcement, what to do in an active shooting situation. Yet, all four of them, as experienced and trained as they were, had no idea how to accept the reality that this was happening. Which is why Lieutenant Willis remembers It's real. Ladies and gentlemen, those 4 people, they were adults. Those 4 trained, experienced people were adults. These 4 were children. And so were
There you go. At the very beginning, when I was watching this, I was like, this is kind of a weak start. The state was really good in their opening statement. It's just hitting the jury hard with emotion and just absolutely just immediately bringing down the mood of the room like a lead balloon, right? It was very, very effective at making the jury understand from the get-go the stakes were so high. And here, at first I was like, okay, I guess, but these are professionals. I don't really care so much about Ed Wogrowski. No offense to him, right? He testified well, but great job, testifying and doing his work. But in terms of the emotion, this is who I care about, right? This and yeah, okay, Molly Darnell and oh gosh, the assistant vice principal, both of them, yes, of course, they were there that day and went through a lot of trauma as well. But at first I was like, okay, I guess. But here it's the juxtaposition of 4 people who are professionals that even with all this training, it still messed them up. And then there are the 4 kids, not professionals, kids who lost their lives that day. So, okay, I can get it. All right, let's continue on.
were the hundreds of kids in that school. What happened that day is about the deaths of these 4 children and what James Crumbley did and what he didn't do. The shooter has been sentenced and prosecuted and convicted. He pulled the trigger. James Crumbley is not on trial for what his son did. James Crumbley is on trial for what he did and what he didn't do. James Crumbley had a willful disregard of a known danger and it caused the death of 4 students in Oxford High School on November 30th, 2021. Hannah, Madison, Tate, and Justin. I'm going to spend a few minutes on the law, but the judge is the authority on what the law is, and she's going to instruct you what the law is. He's charged with 2 counts of involuntary manslaughter under 2 alternative theories. You don't have to find both. You don't have to agree on both. You can agree on both, but either one is the only thing you're necessary to return a verdict of guilty. The first is that there was gross negligence in the performance of a lawful act, and that the defendant caused death, and in doing the act that caused death, he acted in gross negligence. And then the second is his failure to perform a legal duty, and that he knew about the facts that gave rise to the duty, and he willfully neglected or refused to perform that duty, and he failed to perform it, and it grossly negligent to human life. And that the death of the victims were directly caused by defendant's failure to perform this duty. 4 counts of involuntary manslaughter for children who were killed.
So this is an important point is to talk about the elements. What are the elements that the state has to meet? And so, what is she about to go through now by going through all of the evidence? She's going to take each one and put it into a particular box, right? And each box is a particular element of involuntary manslaughter. So that's what she's about to go through. That's why she gave that little outline of this is what we need to show. This is how we showed it.
There can be more than one cause of death. James Crumbley doesn't get a pass because somebody else also caused the death of these 4 kids. And the judge will instruct you on that. It's not enough that you just made it possible for the deaths of Madison, Tate, Hannah, and Justin. You must find beyond a reasonable doubt that the deaths were the natural or necessary result of his acts or failure to act. You heard the evidence about how each of those kids were killed. And as previously noted, there can be more than one cause of death. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that his son's act of shooting someone was reasonably foreseeable. Not that he knew his son was going to kill 4 people. That is not what I have to prove. Just that it was reasonably foreseeable.
And that's an important point here, right? That they don't need to show that he knew what Ethan was going to do, because then that would be murder.
What's gross negligence? It's more than carelessness. It's willfully disregarding the results to others that might follow from an act or failure to act. And in order to find that, you have to find the defendant was grossly negligent, and you must find each of the following three things beyond a reasonable doubt. First, that he knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring someone else. Second, that he could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another one to a reasonable person. A reasonable person. And it must be apparent that the result was likely to be serious injury. In Michigan, a parent has a legal duty to exercise reasonable care to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates unreasonable risk of harm to others if the parent knows that they have the ability to control their minor child and knows of the necessity and opportunity for exercising such control. Even before we had safe storage, there was always a legal duty that existed. That newly passed law has no bearing on your legal duty that as a parent that you've always had. I said this before, there are 2 theories, 2 different ways to prove the same crime. If proven, one of these, both of them, are sufficient to establish the crime of involuntary manslaughter. And again, it's not necessary that you all agree on which theory has been proven, as long as you agree that the prosecutors proved at least one of those theories beyond a reasonable doubt.
Really quick here. And wings, Alita, which way are you leaning and why? Thanks for the super chat. Honestly, I'm leaning guilty. I'm leaning guilty on this one. And it's not because of, guns in general or bad parenting or anything like that. It's the fact that there really is so much here that indicates that there was a major problem that they should have known about. Even if they didn't know about, they should have known about because it was being flagged by other people. For me, the biggest pieces right there were the fact that they didn't make sure that gun was secured. The 6 hour was never once secured. He told the police in the police interview that he was like, yeah, it was in the gun case in my armoire. That doesn't mean that it's secured because it didn't have a lock on it. The gun store employee testified that particular gun case cannot be locked. They didn't use a cable lock. They didn't, and I understand cable locks can be, there are ways of using tools on a cable lock to unsecure it, but like he didn't do these things that were available to secure it. So there's a big issue as to the steps that he could have taken here, and the knowledge that he had / should have had. Even if he's a little bit dense, he should have known, right? This is one of the things about parenthood, right? Is you're raising a human. You a lot of things happen in people's lives, of course. parents get very caught up on all kinds of things that they are trying to do and trying to accomplish and also trying to take care of themselves. But this case right here is there's just so much that seems to have been apparent to other people around them that I just, to me, I see recklessness. I see recklessness. And to me, having a teenage kid who's going through emotional hard times and giving him access to a 9mm handgun is just that to me seems foreseeable. It's foreseeable that could result in harm to himself or to others. So that's my thoughts on that.
I want to stop before I talk about the evidence briefly. I want to know that everyone appreciates how much care and patience you've taken in listening. It's clear and it's obvious, and I thank you for doing that. There are people, though, who think that the prosecutor's job is just to convict people, and that's just not true. It's our job to present you with the facts and tell the truth and to be advocates, and telling the truth sometimes involves showing you things no one wants to see. Sometimes our job requires to produce evidence and testimony and pictures and images that we don't want to show you and no one wants to see them. But that's our job. That's my job. And it's not our job to sanitize, even though that would be easier. It's my job, and it's Mr. Keith's job to present all the evidence to you and explain why we think the defendant is guilty beyond a reasonable doubt. Mark Keith told you when this trial started that any number of tragically small efforts could have saved the lives of 4 kids, that it was foreseeable and it was preventable. And the evidence presented in the last 5 days has proven that, ladies and gentlemen. James Crumbley was presented with the easiest, most glaring opportunities to prevent the deaths of these 4 students. And he did nothing. He did nothing. He did nothing over and over and over again.
So there's the theme. There's the theme that I noticed in their opening statement was that they were tragically simple, tragically easy, tragically small things that he could have done to save lives, and he did nothing. So this is how they are really bookending this trial, is by pointing out that these are simple things that anyone could have done. They don't take a lot to do. So there's the theme right there. So now she's going to go through, I imagine she's going to go through all of the tragically easy things that he could have done, that he didn't do. What are each of these things?
And the evidence shows that. This case is not about holding James Crumbley responsible for what his son did. Again, if he knew exactly what his son was going to do, he'd be charged with murder. It's about his legal duty and his failure to perform it, or to perform it in a negligent way. You heard the testimony of Molly Darnell. She told you that the first thing she saw when she looked through the window and saw the gun being raised towards her was that there was no orange tip, which she had learned previously, she doesn't remember where, meant it's a real gun. That he aimed the gun at chest level and he locked eyes with her, and the bullet landed 6 inches from her heart. Ed Wagrowski, who was a member of the computer crimes unit in the Oakland County Sheriff's Office. He told you about what forensic evaluation of cell phone analysis is. He was qualified as an expert. He described his involvement and observations at the school that day. And he told you that he doesn't really respond to incidents like this. He was in computer crimes. No one comes into the office and says you have to respond to a critical incident. except that day. And you could tell that that had a great emotional impact on him. He watched hours and hours and hours of videos and images of that school that day to put together the evidence that we were able to present to you today and through the past 5 days. He reviewed all of it and he described and then showed you the path and the camera angles of the shooter's path through the school that day. He also presented the messages between Jennifer and James Crumbley and the messages between their son and his friend. He told you that there were over 20,000 text messages between the shooter and that one friend he had. He also told you in 1 year, there were only 65 text messages sent between James Crumbley and his father. James Crumbley, who had either worked at home, was in between jobs, or had DoorDash. James Crumbley, who was the person he dropped his son at school every single morning. He told you that the image of the gun that the shooter shared with his dad was deleted. We played the voicemail from the school on November 29th from Pam Fine, talking about his son searching bullets. He presented evidence that he was aware of that because Jennifer told him about it. She texted, "Did he tell you about what happened at school?" James responded, "Yes." He shared with you the defendant's communications on November 30th of 2021. And important to note, he was able to show you exactly the path that he took. Because of the cell phone data, some of you were probably surprised and a little concerned about how much somebody can actually know what you're doing, but it's a lot. And we know exactly where he was, what he did, who he talked to, and so we could trace his steps, which turns out to be some of the most critical evidence in this trial. He showed you through the DoorDash search warrant returns the locations of what James Crumbley was doing from the moment he left the school that morning until the moment he called 911. And only after he learned that there was an active shooter at the school did James Crumbley go home and look for the gun. Even though from 11 o'clock to 1 o'clock, he had 4 DoorDash pickups and passed his house many times. He's within minutes, many times. And you heard the 911 call by James Crumbley about 14 minutes after he arrived home and discovered that the gun was missing. Bob could tell us, he testified, and we showed you images of the hallway in that school when he processed the scene. And you saw pictures of that. And he told you that a total of 50 fired and unfired cartridges were recovered. And that the shooter fired 32 rounds and 18 were unfired. And we know where he got those 50. You saw that. It's when he pointed them out across the counter when he's with his mom standing a little bit behind her and said, 2. And you also know that James probably knew that because when he was at the substation and they asked about where this gun was, who owns the gun, where's the ammo, he described it as he bought 2 boxes, referring to his son. Bob Catellis told you that those are rods placed in where bullet holes have penetrated that glass. And as you can see, and you saw other images, this was somebody who knew how to use a firearm. And Special Agent Brandon told you that's immediately what he observed. those are shots if landing on a human being would kill them. Cami Batt explained in detail what her requirement is and what she did that day, and that she knew James Crumbley because in June he came in and he bought 2 more guns, one for himself, which the evidence showed, because he told Jennifer how much did your gun cost? It was $300. And then there was another gun, which was his son's, a Derringer, and you saw the Derringer. She told you that she also sold him the 9mm on the 26th, that his son was present with him. He stated he's had his eye on that gun. She told you that they sell a locking mechanism with each gun they sell, that he was provided the trigger lock statement, and that there was a cable lock with the Sig Sauer when he bought it, and it was provided to him, and the ATF pamphlet solely in existence to just warn people, once again, the dangers of firearms with minors. And she told you that regardless of what kind of mechanism they provide, they always try to provide a tool with anyone who purchases a firearm to make it safe. Sergeant Joe Bryan testified and introduced the video, the recorded statements of James in the substation. James' statements indicate he knew that his son had only one friend and that he left abruptly. He referred to the math worksheet that morning as some doodling on a paper. But that was after the shooting.
Which, the defense was really trying to hammer in like, well, he didn't have any concerns that morning, right? He didn't have any concerns about Ethan that whole day, basically, which is like, okay, that's fine. So then you can get to, that he didn't know that there was a risk that was being created, but he should have known. Like I said, there's still the reasonable person side of that analysis.
Before the shooting, we know that he texted Jennifer Crumbley WTF when he saw it. Now he's downplaying it. It's just doodling. When asked how many rounds, he corrected Jennifer and indicated there were a box of 50 rounds that he bought his son. When asked where the gun was, James responded, it was hidden in an armoire, in a case, and the bullets were hidden in a completely different spot underneath some jeans. We're going to get to that. What James didn't say that day, no mention of any lock. No mention that the school wanted them to get their son help that day. And then when they couldn't, within 48 hours. And here's something you never hear him say. You hear him say the gun was hidden. You hear him say that there was some doodling on a paper, that he was a perfect kid. But here's what he never says. He never says, I don't know how we got it. Never said that. He never says,
it's interesting.
It was hidden. I have no idea. I can't imagine how he got a hold of this gun. Never mentions that. 4 kids just died. Your son's in custody because he committed a school shooting, and not once do you say, how did he get the gun? And you know why he didn't say it?
Because he knew.
He didn't say it because he already knew. He knew his son had access to the gun. Christy Gibson Marshall, as we just talked about, heard gunshots, saw kids running in a way that wasn't normal, went towards the shooting, identified and spoke to James Crumbley's son, and you saw that video, how she just stood there. Sean Hopkins. Sean Hopkins was a counselor. He testified that the shooter was looking up bullets the day before. He was aware of that. That morning he was told he was watching violent videos. And he told you that even in a 20-minute period of time, he was concerned enough to call parents and ask them to come to school right then. He told you that he said he needed help right away. He wanted them to give him some help right away. He told you that he was very concerned about the images, but his main concern was for the safety of the shooter. He told you he didn't want him to be left alone. And he said in that meeting, he never received relevant information from mom and dad. It was short. It was a very, very small period of time for a meeting that takes place when you have to come from your work. James was at the barn at the time. Go to your son's school. They were in and out of there in a very short period of time. He testified. They said that just couldn't happen today. They had to work. Now, you've heard the testimony. You know what James Crumbley was doing as employment during that time. And defense counsel and I agree. That is a worthy endeavor, being employed regardless of how you choose to do it. But what's important to note is that DoorDash is not something that you can create your own hours. You can work when you want. It's not compulsory. You can work on the weekends. You can work anytime.
I am going to push back on that a little bit. And mind you, overall, I'm agreeing with the state's case. So like, this is not, this is not me like hating on the state at all. They've put on a fantastic case this trial. So I'm going to push back on that a little bit, because when you think about DoorDash, there are, I mean, with any of these kind of like sharing sort of freelance economy kind of jobs like Uber, DoorDash, this kind of stuff. There are certain times that you get peak times and other times that are lull times. And it can depend on where you go, your geography, and what are the different like moving patterns of people nearby. And with something like DoorDash, unlike Uber, there can be a number of reasons why somebody's using Uber, right? It could be that they're going out for the night, they're going out to dinner. It could be that they just don't want to drive to a particular area. It could be that they're driving to the airport, and they need a ride. With DoorDash, it's pretty specific, right? You're ordering food that you want to eat for a meal. So understandably, I would think that there's probably more of a greater likelihood of there being these like peak times and then these low times with DoorDash. So it kind of makes sense to me on a certain level that James wouldn't have signed into DoorDash before this meeting, because who's ordering DoorDash at 8:00 in the morning? Most people aren't, right? Most people have breakfast at home. Lunch, however, a lot of people are at work. They can't get up from their desk because they're working really hard, or workaholics, or any number of reasons. They've got a deadline, right? There are any number of reasons why an American who is an American employee is going to just request food to come to them rather than getting up to go and get it. And so it makes sense that he would sign on when he did. That also indicates that yes, you have flexibility technically on when you can work and when you decide not to work. Absolutely, you do. You don't have anyone telling you if you don't sign on to this app on this date, you will be fired, right? There's none of that. But there is a certain like strategy for if you are trying to make money off of this and you're trying to support your family, that you are going to be very, very incentivized to be very focused on working certain hours and then not working other hours. The lunch rush would be one of those that I would think. So also, he had just lost his previous job, and I never heard any sort of testimony as to what that previous job was, which I kind of, I wonder if he had testified. I mean, the defense probably would have asked him if he had testified what that was. I wonder if it was more of like a desk job, more of a professional job. What were the circumstances under which he lost that job? Was he laid off? Was he fired? Was it COVID? Was it, what was it? There were some indications in some of the exhibits that I don't think I mentioned in these, that there was an indication of money being tight. Oh, it was in some of the journal entries. Maybe one of those that I breezed over, but money being tight in the family. And so it also wouldn't surprise me if James Crumbley also was dealing with some level of depression over like losing a job and then having to DoorDash, even though it's a perfectly valid job. It's, it brings in money. It's you're doing something to support your family to bring in the money. But his wife being the main breadwinner, like I wouldn't be surprised if he was going through his own emotional thing at that time. And that maybe that was impacting his ability to see the things going on around him. That's maybe one thing that hasn't really been explored by the defense in this trial that would have been interesting to see, to look from that perspective at him. This is an interesting point earlier. Fido Law said big elephant in the room is whether James deliberately let his guard down due to the affair. And was it passive aggression from James because of the affair? Yeah, I don't know, because we haven't had any evidence in this trial about that happening. I know that came up in the Jennifer Crumbley trial. There was that text or that Facebook message that she unsent to a Brian Maloche about being out on the run. That seems like the kind of thing that you would only tell like someone who you're like intimately involved with. I don't know if that's the person or not. I didn't catch any kind of a name as to like who she was having an affair with, but I just remember that being something that came up. Anyway, all right, let's continue on. But I was having those thoughts about the whole DoorDash thing about like, yes, technically it's flexible. Not entirely when you look at like what the actual experience is like.
Nick Ejak is the dean of students, testified that he was also at the meeting and that James Crumbley seemed irritated. And that at the time they knew only a fraction of what was going on. No one told anybody at the school. They just purchased him a gun. Neither one of them. James Crumbley didn't say, you know what, we had this fight before. They mentioned about the fight the night before about grades, but didn't really discuss it as a big deal. Didn't really discuss the gravity of what it was like for his son, who had one social connection to the outside world, and that person abruptly left with, and that his son found out because he just stopped texting him back. And that he was obviously so concerned and upset that he communicated that to his father because his father reached out to the friend's father. He didn't say that. He didn't say that the weapon wasn't secure. He didn't say that there had been signs that something wasn't right. Now, you may not like what the two people who were employed by the school and had contact with the Crumbleys that day did. You may not like it. I don't like all of it either. But my job isn't to present to you the evidence that just looks good for my case. My job is to present evidence to you, all of it, because this is about the truth. But he doesn't get a pass because you don't think the teachers did enough. He doesn't.
That's true. That's very true. That's a good point for her to make here. Is like, okay, even if there's blame at the school, that doesn't mean that he gets off the hook. Sarah, thank you so much for the super chat. We need to remember hindsight is 2020. No one actually knows what they would do or say in reality. Not saying they were perfect, but we don't know. Absolutely agree. I still think, like I said before, I'm leaning guilty on this. I still think that it's worthwhile to extend, an empathetic ear to the defense case, right? I know that there's a lot of people that are very happy to jump all over the Crumbleys and what they did and didn't do and failed to do and all this kind of stuff. And I get it. I understand people died, right? That people are justifiably very, very angry about it. And especially hearing about all of the facts that, that have come out. But at the same time, when we're talking about foreseeability, keep in mind that we're not just talking about what he saw as foreseeable, like what he thought would happen. We're talking about what is reasonably foreseeable, meaning what would a reasonable person think that could lead to, right? Like we got to take a step back and be like, is this the type of harm that can result from this kind of action or inaction? And yeah, school shootings with high schoolers getting access to guns, that is a thing that is foreseeable in today's day and age. Maybe before Columbine, that would be not foreseeable, right? But like today, I think it's highly foreseeable for a lot of people that school shootings are a really huge topic in today's day and age in the United States in particular. So it's like, when we talk about foreseeability, just to kind of differentiate it for you guys, we're not talking about like, let's say there's a case where I'm taking this back to law school. There was a case, if I remember correctly, that there was like a people waiting at a train station, and a train ended up like like blowing up like in some part of the car, and this ended up causing harm to people, and so there was a lawsuit over that harm. However, the harm that the person ended up experiencing was not like burns or explosion or anything else. It was something else that had been unsecured or something like that had fallen. And the question was, is this the type of harm that we think could possibly result from this type of problem? An explosion on a train, we would think explosions and that kind of thing, not necessarily some heavy object falling on a person. Don't get too in the weeds on that one, because there are ways that people can totally argue back and forth on it. But like, that's kind of what I mean is like, is this sort of the thing that kind of reasonably makes sense? And in my opinion, yeah, I totally see foreseeability here.
Doesn't get a pass for that. And the blame shifting is only meant to send a message, I'm not accountable here at all. Even though I bought the weapon, even though I didn't secure it, even though I never got help from my son, even though I could have taken him that day. Special Agent Brandon testified where he was when he heard about the shooting, what he did when he got to the school, how he traced the gun, how he found out who owned it. He watched the surveillance. He noticed a couple things that were really concerning to him. One, it was somebody that was proficient with a firearm. He did what's called a combat load, which is unusual. The way his stance was, the shot he took that killed Tate. This wasn't somebody that wasn't experienced with a firearm. And logically, he wanted to know where this person was taught how to handle that weapon, where that minor was taught, that 15-year-old. And he discovered that. He testified that the cable lock that was seen in pictures was sold with the SIG, and it was the cable lock that was seen in the photos. And then he testified that they found that cable lock shoved in another gun box in the kitchen in a cabinet behind a door. You also heard him tell you that the minute he looked at that drawing, he instantly noticed the gun. It wasn't just any old gun. It wasn't. And maybe you wouldn't have picked that up, but Special Agent Brandon did. And you know who else would have known? The person that purchased the gun, James Crumbley. Detective Stoyek talked to you about the search. You saw pictures of the search and the house. You saw where the gun box and the ammo box were when they searched the house. It was on their bed. You also saw a map and learned a pretty small house. Pretty small. You learned he had 2 bedrooms. And you learned that in that master bedroom, which was small, there was the bed, some nightstands, and 2 other pieces of furniture. The TV stand, where he found the 2 other weapons that were in a gun safe, a locking mechanism with the code set to 000, which is the default. Detective Stoyek and told you what others did. He never, ever, ever said that SIG was locked. He said it was hidden. David Hendrick is in charge of the Fugitive Apprehension team. You learned what that is from 2 law enforcement officials. You learned that on the day the defendants were charged, they left a hotel in Auburn Hills, local, and drove all the way to Detroit in a building that is meant for businesses, not retail. People don't sleep there. And you heard what it was like when he arrived on the scene, when they were searching for James Crumbley and his wife. You heard through the body cam of the Detroit officer, and you heard from Officer Hendrick, and you heard from Luke Kirtley that it was extremely loud. There were dozens and dozens and dozens of law enforcement, and most of them SWAT. Luke Kirtley told you about how James Crumbley was discovered that night. And the only reason he knew it is because it was all over social media with the description, the license plate, and picture of James Crumbley and Jennifer Crumbley. Why? Because they were charged. And even before they were charged, there was a lot of speculation about them being charged. Luke told you about what that building looks like, what it's for, who's normally there at night, not many people, that he shares a wall with that studio that they were found in, that mattress they pulled in was out in the hallway. He again told you how loud, and that it would have been impossible if he was in his unit not to hear that. Officer David Metzke told you that there were tons of officers, multiple agencies, and that they took a 35-pound steel ram to bypass multiple doors, and they used it, and it was loud. I think he testified we have the bigger guys do that. We saw through his body-worn camera the arrest of James Crumbley, who was laying on the mattress and seemed to be wanting to create the impression that he was sleeping. There's a big problem with that. One, we know that shortly after Luke Kirtley went out to see the license plate, that he followed him shortly after, and he was away. And shortly after that, dozens and dozens and dozens of law enforcement show up on the scene. It's a first floor unit. The windows face that parking lot. Lights and sirens, media were there, yet he's lying on a bed as if he's sleeping. William Creer told you what they discovered. They had bought and purchased, they had purchased items with them, socks, new socks. They had clothing, they had food. There was a whiskey bottle in the trash can. There was ice. But here's the thing that was the most compelling about his testimony. The bag with the 4 phones that were turned off and $6,000 of cash was stored on the other side of the room from the backpack in a lid in a plastic bin with a lid on it.
Okay, so that's the answer to my question: $6,000 in cash. So that was something that was just a detail that I must have missed as I was watching testimony. But there you go. She's here to reinforce it. And by the way, another thing about the closing arguments is, I know I mentioned this with the Hannah Gutierrez Reed case, but it's worth repeating, especially if there are new folks here that didn't watch that trial with us. That the closing argument, one of the main goals of the closing argument is, like I said, it's to tie everything up with a bow, right? Package it nicely so that the jury can go into deliberations room. But specifically, they are aiming to give as much, sorry for the word, but ammunition to the people on the jury who are most likely to be in favor of their side so that they can go back and argue on their behalf. So as much, as much fuel that they can give them. I'm trying not to use these other metaphors that just like naturally come up because I understand the sensitivity of this trial, but as much fuel as I can give to these people who are potential supporters, is like what they are trying to do, because they are going to become the further advocates when talking with the other jurors in the deliberation room. Okay, let's continue.
That is strong circumstantial evidence, which is used in this country every day to convict people, that was placed there in hopes that no one was going to find it.
Yeah, it did look like it was being
$6,000
hidden.
cash, 4 cell phones turned off, which is odd if you're really trying to get up in the morning and go somewhere, and the alarm was set on one of those phones, but they were off. But what did Ed Wagrowski tell you? He told you that you can't track a phone if it's off. You can't track it. We all learned, if you've learned nothing else, turn your phone off if you don't want to be tracked, because there's all sorts of ways. Lieutenant Willis testified. He showed you the bank records showing what they did when they found out that their son was charged and when there was talk of them being charged. He talked to you about the scene at Oxford High School. And it was a really detailed description of what it was like in that school that day. Because hundreds and hundreds of law enforcement officials went to that school, some miles away. No one asked them to. They just drove there from all different parts. And so it was Tim Willis's job to take all of those people who wanted to help and give them something to do and get the scene processed and start building a case. And answering questions, which is really what an investigation is about, way before you get to a prosecutor. Because sometimes you never get to the prosecutor. Your job is to go where the evidence leads you. And there were things about this case from the very beginning that just seemed like questions that needed to be answered. And one of them was, that gun was purchased 4 days earlier by James Crumbley, who was the same person who was at the school that day. This is information they're learning immediately. They do a search warrant for the house and for phones, and they find out a lot of information. You saw the video of the shooting. There's a reason we tell the media they have to turn their cameras off. We don't want those images out there. We don't want them to be on the internet.
Yeah, I'm grateful for that.
We don't want to encourage another school shooting. And we don't take any pleasure in showing it to you. But it's our job to know the truth and look at it and not look away. He told you how each of those kids died. Hannah was hit immediately after he left the bathroom. You saw the image and it was described to you. Madison Baldwin didn't run. She crouched down. There was a door 4 feet from her. And she put her hands over her head. And he walked right up to her and he shot her at close range in the head. Tate was shot. I talked about that shot he took as he was coming in the door. He had his headphones on. He didn't even know what was going on. And Justin Schilling was shot in the bathroom after several minutes of being in there. It wasn't immediately. Shooter went into the bathroom, stayed there. Justin knew the shooter was there. And there was another student in there as well. You saw him running, Keegan. And he ran after James Crumbley's son shot Justin Schilling, execution style.
This is, of course, to bring it back to the emotions after they've been kind of going through the factual arguments, and it's just making sure that the jury's still paying attention. And if they haven't been, sort of drawing them back in.
Defendant's son had access to and the use of this gun. It was preventable and it was foreseeable. you heard during jury selection and you heard during opening, and if my prediction is you're going to hear it again, that this could be you. This could be any of us. This is what this is their defense, that this could be you if you let your kid drive a car or leave with a sharp object. This couldn't be everybody. This couldn't be the person that takes their kid hunting. This couldn't be the person that buys a gun for their child to use, for their minor child, for their use. That doesn't create a criminal charge, ladies and gentlemen. It couldn't happen simply because you purchased a firearm or simply because you let your kid drive a car. Beware of the claim that this could be you. Beware. It is not the case that finding James Crumbley guilty of gross negligence would result in a criminal charge for every parent who doesn't know what their child is doing at all times. And it is not the case that he was faced with the same normal challenges as parents that we all go through and suddenly found himself in a courtroom being charged with involuntary manslaughter. It is just not the case, and the evidence shows it. In June, the Derringer and the Caltech were purchased by James Crumbley. We know that Caltech was left out, unsecured, with ammo. Why do we know that? You saw that picture and video and the one he sent to his friend, and you saw the text that accompanied.
Okay. At first I was like, when they searched the house with a search warrant, that was in a gun safe. I thought she was maybe going to argue like, oh, because the gun code was, or the gun safe code was the default code or something like that. But what she's referring to is the text message that Ethan sent his friend saying, Dad left this out. So I thought, why not? And then he sends like a video of him like manipulating the gun.
Before we get to that, this is an image from the video that you saw. It was 12:30 at night. That is his cat, Dexter. That is the shooter's cat. That magazine is loaded and it was shoved on a table to load it, not a proper or safe way to handle a firearm. And there is a round in the chamber and the safety is off because red means dead. And Special Agent Brandon told you that. Even if James Crumbley was standing next to his son, that would still be an extremely dangerous way to handle a firearm. But we do know what happened. Because he told his friend when he texted it to him. My dad left it out, so I thought, why not? This is precisely the reason there's a legal duty in the state of Michigan to prevent your kid from harming himself or somebody else. All I need is my 9mm pistol, which I currently am begging my dad for. This is from his journal. First off, I got my gun. It's a Sig Sauer 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I have access to the gun and the ammo. Then we have defendant's own statements. James Crumbley said it's a substation. James responded when it asked where the gun was. It was hidden in our armoire in the case, and the bullets were hidden in a completely different spot underneath some jeans. Here's what he doesn't say. Never claims it was locked, never says it was inaccessible to his son, and again, never says or expresses any surprise on how his son got a hold of it. We know he took him to the range. We showed you videos and images of that. In fact, 8 times we know that happened. We know that throughout June, July, August, September, October, by November, when he begged his dad for the 9mm and he actually did buy it for him, now he's at the point where he can instruct other people. It's James Crumbley's son that knows more about guns and when he takes his mom to the range. And how did he learn? James Crumbley taught him.
I don't know.
He didn't take himself to the range with his dad.
Objection, facts, not evidence. Like there's been nothing. There's been nothing. I mean, okay, other than the fact that James and Ethan went to gun ranges before and they shot 9mm together. Okay, maybe, or maybe this kid also watched a bunch of YouTube videos. You know, I mean, there's a lot of possibilities here. I'm not convinced that that's like the on that specific point.
This is the shooter 2 days, 1 day after the gun was purchased for him. He's packing it up. What don't you see?
The cable lock.
The cable lock.
Yeah.
It's not even in the case anymore.
Yeah. Because it was found in the Caltech case.
And there it is. That's the cable lock that was provided that day with the pamphlet and with the gun. Just the day before. It's already out of the case. Here's where the other 2 guns were found in that bedroom, in defendant's bedroom, in a safe. In the TV stand. The code was 000. The important thing is that the SIG could not fit into that gun safe. Could not fit it. It's impossible. But the other important thing is you're hearing a claim that James Crumbley didn't think that he had to lock his weapon up. Okay. It's not about whether you locked the weapon. It's about whether you made it secure. And we already know he felt the need and understood his duty to lock the other 2.
Really quick here. Troy Scott, I've got 3 cable locks that have never been opened. The kid could have easily cut through the cable to get the gun. But I completely agree with you. Yes, there, like I said before, there are totally tools that can be used for it. But at least that's an affirmative step that the parents would have made to secure the gun. You know, like you can't just like assume, well, this kid can probably get around it, so therefore I'm not going to try. Like that's, you know, we don't want to go down that line of thinking either, because him cutting through the cable to get to it would have been on him, not on the parents. I've got some questions here that I'm gonna wait. Yeah, I'll wait until the end of this, unless there are some that are pertinent to the here and now. Let me just double check. Okay. Yeah, I think we're okay to answer these questions later. Okay.
Special Agent Brandon read to you the lines if he had opened it up, if he had read it, if he had believed it, those deaths could have been prevented. If he had just read it and just did the simplest of things. This is the crime scene. There were 32 shots fired that day by James Crumbley's son. How do we know this was foreseeable? The shooter says in his journal, I have zero help for my mental problems, and it's causing me to shoot up the fucking school. You heard a lot during jury selection and opening about kids exaggerate to their friends. This is his journal. He's not sending it to a friend. He's expressing his state, which was desperate because he needed help. I want help, but my parents don't listen to me, so I can't get any help. My parents won't listen to me about help or a therapist. I can't even say with a straight face or even find a way to explain the rationale behind a 15-year-old that desperate writing that in a journal because he was exaggerating or lying. We have the text between James Crumbley's son and his friend about exactly what he wrote about in the journal. He hears people talking to someone in the distance. I actually told my dad, asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up. Again, teenagers exaggerating to make themselves look better, to impress. None of these text messages to his friend make him look better. None of them make him look impressive. They just make him look desperate and sad and wanting help. I'm having bad insomnia and paranoia. I need help. I was thinking I could call 911 so I could go to the hospital. This was in April. But then my parents would be really pissed. I'm going to ask my parents to go to the doctors tomorrow or Tuesday again. But this time I'm going to tell them about the voices. And then on April 5th, like I am mentally and physically dying. What did James Crumbley know? He knew the family dog had died. A grandmother had just died. His son's only friend, the one person he had any social contact with, abruptly leaving, can't even text him. Knew his son was completely isolated. Knew he had looked up bullets the day before. Knew he was upset the night before. Knew he had been watching videos that morning, violent videos. And then he sees that drawing. He sees that drawing that morning when he goes to the school. And what does it say? It says, "Help me." How many times does this kid have to say it? He says it in his journal. He says it to his friend. And what is he saying? I asked my parents. I asked my dad. And then if that isn't enough, he writes the words, "Help me," on a piece of paper. And his parents, James Crumbley, is called to the school to see it. And what does he say? He says, "We got to go to work." He describes his son as a perfect kid, never gets in trouble. Well, you know, if you have a perfect kid that never gets in trouble, being called to the school abruptly that day and asked to come and saying your kid needs help is about 100 out of 10 in terms of how troubling it is for a parent, if it's that unusual. He knows his son is proficient with guns because 4 days earlier, he purchased that weapon for him. This is James Crumbley's son on the morning of the shooting, November 30th, being dropped off like every day by James Crumbley. And here's the worksheet. The thoughts won't stop. Help me. You have a picture of someone bleeding with bullet holes. You have a picture of the exact gun. It says blood everywhere. My life is useless. The world is dead. This is the worksheet James Crumbley looked at when it was texted to him. This is the worksheet he sat and looked at when he sat in that counselor's office. Those are the words he was reading when his wife said, "We can't do that today. We have to work." And he said nothing. And he leaves with a piece of paper with the names to call. This is what he was looking at. And there's the piece of paper. It took just one tragically small measure of ordinary care to avoid 4 deaths.
I would be curious to know if there's a split among parents and non-parents as to like how they feel about this case, because I feel like that's also an experience that can absolutely inform someone as to how they feel about this kind of thing. You know, I don't have kids at this point. Want to have kids, but don't have kids at this point. But it's like I do have nieces and nephews, and I just if I ever were made aware of what was on that worksheet, I would be freaking out. I would be absolutely freaking out. At least I would think that I would be. You don't know if you've never been through it, I guess, but I don't know. I just it's just it's hard to think that, that you would say, "No, we have to work. This is important, but it's not that important." I don't know. I don't know.
James Crumbley failed to use ordinary care, which could have prevented the death of these 4 kids. Didn't stop at home to check to see where that gun was. Even though you can't take him, which we know he could have driven around with him. He could have not done any DoorDash run until Jennifer comes back from work. He could have gone to see where that gun was. We know that in his DoorDashing, he was minutes away from 11 o'clock to 1 o'clock. He didn't search or ask to see the backpack. Never thought then to say, "Hey, can I talk to you out in the hall?" Or, "Hey, where's that gun?" Didn't ask his son where that gun was. Didn't check the journal, despite acknowledging he had one. Didn't lock and secure ammunition. Didn't lock or secure the gun. Didn't take his son home. Didn't take him to get this care that a counselor's telling you he needs. Didn't say, "We bought him a gun 4 days ago as an early Christmas present." And didn't tell the school much relevant information at all. And Sean Hopkins told you that. He also didn't disclose any of the instances that you were shown throughout this trial. That there was a message in March about him doing something stupid. Jennifer Crumbley was concerned about it. James was always home. "Is he home yet? Is he home yet? Is he home yet? Leave me alone. I have to work. He's fine," is what he says. The incident about giving him melatonin and him being worked up. Didn't tell him that he'd asked him for help and asked to go to the doctor. Told him to suck it up. Didn't say about the friend and how it was his only person he ever had any social contact with. That there were multiple guns in the home, that he was begging for a 9mm. James Crumbley never even shot that gun. He didn't fire it once. He had it, he purchased it on Friday. On Saturday, he was gone all day doing DoorDash. On Sunday, he was gone all day doing DoorDash. And that he wants you to believe he had this secure hiding spot. What, it was a hiding spot for 1 day? We know it wasn't there on Saturday. We have the shooter taking pictures of it. And we know the cable lock isn't around. And we know Jennifer leaves. He's alone with his gun. Didn't say that it was identical to the one in the drawing. Didn't say he bought 50 rounds to take home. Expensive rounds to use at a range. This is the DoorDash information from 11 o'clock to 1 o'clock. And all of the times he passed that house. He was within minutes. We know that he was absolutely concerned about this worksheet until after the shooting in the substation where he says it was doodling. We also know that not once on any of his devices did we find any searches or information he was trying to get about firearm safety or how to make sure a minor doesn't get a hold of it, laws, any of it until after the shooting. We know that at 10:37, he arrives at school. His son leaves at 10:52. They're gone by 10:53. At 11, he logs on to DoorDash. He completes 4 orders. He tells us in the 911 call and at the substation, he saw cop cars. We know that 12:51, the shooting starts, and we start to see students and parents, we heard, arrive at the Meijer. They're being told by dispatch that's where the reunification time is. James drops off his last order at 1:01. The email comes out from the school at 1:09. At 1:11, James is in the Meijer parking lot. It's unclear exactly why. He calls his wife for 57 seconds. That's the call lasts 57 seconds. He's on the phone with her for 10 minutes and 19 seconds. He gets home at 1:20. During that call, she texts her boss, the gun is gone and so are the bullets. So we know that by 1:23, both of them had knowledge about that. He calls her again, 1:30 to 1:33, another 3 minutes, and finally calls 911 at 1:34. There were 1,800 students in Oxford High School. There was one parent who suspected their son was the school shooter, and it was James Crumbley. You know what that's called? It's called foreseeability. That's what that's called.
What's the location of your emergency? Okay, I'm not really sure. I'm at my house. There's an active shooter situation going on at the high school. My son goes to high school. I have a missing gun at my house. I need an officer to come to my house right away, please. Okay, I'm not going to be able to send anybody to your house right now. So they're on the active shooter situation. I understand that. There's a million out there. I have a missing gun, and my son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper, and then I was down and I saw a whole bunch of cops somewhere, and I made sure that I wanted to get to the hospital, so someone was going to the high school, and then somebody told me that there was an active shooter, and then I raced home just to find out. Okay, and I think my son took the gun. I don't know. I don't know what's going on. He's really freaking out. My son's name is Ethan Crumbley. Crumbley. All right, sir, I'm going to put your phone for just a second, okay? I have to talk to Kirtley and see if I can do anything for you, okay? Thank you. Okay, good.
You just heard this. I have a missing gun. My son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper. And then I saw cops going somewhere. I wanted to go to the school, see what was going on. I heard about the active shooter, and I raced home just to find out. We don't have to discover or argue about whether or not he was put on notice that something was really, really wrong. He says it. He says it. He calls and he says, because of this meeting at the school, and because I have a gun, I went home to look for it when he heard about the shooting. So the question of whether or not that did concern him, it's not a question. We know it concerned him because he said it. And then at the substation, and this is what he says, and somebody said there was an active shooter, I immediately freaked out because the situation. And after I saw all the cops, after I found it was an active shooter that went on this morning, and after what went on this morning, what's he talking about? He's talking about the meeting and the words on paper. It says, help me, blood everywhere, with a picture of the gun he bought him. So I raced home and I found the gun missing. We went into detail about what James Crumbley and his wife did after they thought they might be charged with a crime. And the evidence clearly shows what they didn't do. They did not turn themselves in. They did not make sure that they were in the area. They withdrew $6,000 and they went to Detroit and turned the car around so the license plate is not facing, and didn't go out and buy that stuff themselves. They sent somebody else.
Okay. Yeah, they didn't turn themselves in. The defense on those points did make some points to say, we don't know if they knew that they had been charged. Okay. State is making a lot of good points. That's not one of their strongest ones.
And lastly, defendant conflicts his own statements. At the substation, the drawing was doodling. When he received it from his wife, he's concerned, my God. WTF. He says at the substation, I immediately raced home and found the gun, and that's when I called you. I called you guys right away. It was 14 minutes after he got home. You think your kid has this gun, you know he does. You know he's really upset, you know the words he wrote, you suspect he's the shooter, and you wait 14 minutes to call 911? He doesn't know when a shooting started or when it ended. I think you owed something to the parents and the kids in that school to at least try, once he did figure out that the gun was gone, which any reasonable person would have known. But why lie and say you call right away? You called after a 10-minute conversation with your wife. At the substation, he's a perfect kid, doesn't get into trouble, yet he was looking up bullets, and yet they were called to the school and the drawing. He doesn't say that, or what the drawing was really about. It's a downplaying situation. And then he says the gun was hidden. And again, never once, I don't know how he got it. Never once says that. James Crumbley had concerns that day. He knew something was wrong. He said it in his own words. And we know that because of what was on the drawing. And we know that because we know what his response was when he received the drawing. He kept those concerns private that morning. But he didn't just fail to inform the school. He failed to act. James Crumbley failed his son in a tragic way. You're not going to hear me say that's not true. But he didn't just fail his son. He failed Hannah. He failed Madison. He failed Tate. And he failed Justin. He failed to perform his legal duty to prevent these kids from being killed. And he failed their parents, too. And I ask that you find him guilty. Thank you.
Thank you, Prosecutor. Ms. Lynn?
Yes, Your Honor.
Okay. Now defense closing.
There were a variety of emotions following the shooting on November 30th of 2021 at Oxford High School. Terror, anger, and devastation. There's an epidemic of mass shootings in our country. School shootings in particular have devastated our communities. There have been social and political groups formed to address these issues, but so far they've been unable to do so. However, on December 3rd of 2021, the parents of a school shooter were charged with involuntary manslaughter for the first time. When we started this trial, I said that the events of November 30th of 2021 undeniably changed people's lives in ways that most of us will never understand. We know that 4 children were killed, multiple families were devastated, and communities were terrorized. And ladies and gentlemen, James Crumbley and I do not dispute any of that. We heard from people who were at Oxford High School on November 30th of 2021. We not only heard what they had to say, we saw the impact that day had on them. Multiple people told you what that day was like. They told you what they felt. They told you what they saw, and they told you what they experienced. You were also shown videos of what happened inside of the school on November 30th of 2021. We can agree that you all heard a lot about what happened inside of Oxford High School on November 30th of 2021 through videos, and testimony. This case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. This case is about what James Crumbley knew on and before November 30th of 2021. James Crumbley was charged on December 3rd, 2021 for the deaths of Hannah St. Juliana, Madison Baldwin, Tate Meir, and Justin Schilling. As you've seen throughout this trial,
It is interesting that she's not shying away from the tragedy, from the victims, from, you know, naming names who have been harmed by this shooting, because it's the message that she's saying is like, yes, this was horrible. Yes, I agree. Yes, the victims deserve justice. But she's saying this ain't it. That's her whole point here. And I think it's a position of strength that she's coming from. Whether it's going to be successful or not, I don't know. You know, the facts are the facts, right? I've already said how I feel about this case. And it has nothing to do with the lawyering. It has everything to do with the facts of the case. I think she's put on a very competent case so far. And so far this closing is pretty decent. So far. We'll see how it goes.
the charges and allegations against James were based on assumptions and hindsight about James and his knowledge about his son, who we've referred to as either his son or the shooter. The prosecution is asking you to second guess the decisions made by James Crumbley on November 30th of 2021 and before those days. And as Sean Hopkins told you, it's easy to look at things in hindsight. But we aren't here to look at things in hindsight. We are here to look at what James Crumbley knew prior to and on November 30th of 2021 before the shooting began. You heard no testimony and you saw no evidence that James had any knowledge that his son was a danger to anyone. You heard no testimony and saw no evidence that James Crumbley knew what his son was planning. You heard,
and this is, well, okay, but that is a point that the prosecution has already addressed in their closing argument, right? That they were like, if he knew what his son was going to do, then he'd be charged with murder. So like, we don't have to prove that. So she's going hard for that, and I commend her for it. She's doing a competent job. But on that one, I was actually pausing it just to say, like, this is the point that she's been hammering on every single cross-examination at every possible opportunity is you don't know that James Crumbley knew about this journal. You don't know that James Crumbley knew about these text messages that he was sending to his friend. You don't know that he knew that Ethan was, or the shooter was, playing with this gun in this way. She's been really hammering that with every single cross-examination here. And that's basically the theme of her opening and closing, right? That's the theme of the defense case, which is he didn't know. And if he didn't know, he couldn't have reasonably foreseen any of this. He couldn't have, he couldn't have consciously disregarded any kind of a risk. That's more where that goes as opposed to the foreseeability issue. But, and that therefore he can't be convicted of involuntary manslaughter.
Heard no testimony and saw no evidence that James Crumbley was aware that his son knew where the firearms in the home were hidden. You heard no testimony and saw no evidence that James Crumbley was aware that his son had obtained access to those firearms and had handled them unsupervised. Still, the prosecution wants you to find that James could foresee that his son was a danger to others and that James acted in a grossly negligent manner or breached a duty that he owed to other people despite having no information at the time.
No information is a little...
You obviously know that the defense has no duty to present a defense. We talked about that during jury selection. The judge will give you instructions on that and the law on that. But we did bring out more information so that you all had a more full picture, a more complete picture of what happened in the days leading up to November 30th of 2021 and even on November 30th of 2021. But in the end, if you have any questions, if there's anything that you're unsure of, If there's anything that you're wondering about, the prosecution was the only one that had a burden of proof. When it comes to burdens of proof in this country, beyond a reasonable doubt is a very, very high burden. In civil cases where people sue each other for money, the burden of proof is 50-50. Preponderance of the evidence, whether or not somebody gets money and somebody has to pay money. In cases where the state wants to take your child due to abuse and neglect, it's clear and convincing evidence, a little bit higher. Beyond a reasonable doubt is the highest burden in our country, the highest burden of proof as it relates to criminal prosecutions. Judge Matthews is going to instruct you that reasonable doubt is just that, a doubt based on reason and common sense. It can be based on the evidence, or it can be based on the lack of evidence. When it comes to reasonable doubts, you can have 1 or you can have 10. You don't have to have the same reasonable doubt as your neighbor. What matters is that if a juror has a reasonable doubt, then they must vote not guilty.
Claire Niam, this bit seems taken from the last Crumbley case. Well, this is like defense closing 101, right? Is talking about the standard of proof and how, in a criminal case, state has to prove it, not just, showing that it's kind of likely, but that it's beyond reasonable doubt. If you have any amount of reasonable doubt, no matter where it comes from, as long as it's reasonable, that you should acquit. So this is standard.
You can believe
right?
that if the prosecution had evidence that James Crumbley knew that his son was a danger to others, you would have seen it. Especially if James knew what was inside of that journal. We've heard about the journal. If James knew what was in that journal, the prosecution would have told you that. If James knew that his son had gained access to his firearms, the prosecution would have told you that. You definitely would have seen it. And the fact that you have not seen any of that evidence can be your reasonable doubt. You can also believe that if the prosecution knew that James Crumbley knew that his son knew where the firearms were stored, the prosecution would have told you that. You would have heard about it, but you didn't because James didn't know. He didn't know that his son knew where those firearms were. Absence of evidence that James knew that his son had learned where those firearms were can be your reasonable doubt.
But he also knew that the 6 hour wasn't locked. Like that's the part that the defense really loses me. Is like he knew that the 6 hour wasn't locked because he described exactly where it was in the home, or where he kept it in the home, which was in the gun case in his armoire. And he knew that that gun case was not locked. He also knew that the armoire was not locked. So it's just this is really like, this is one of these parts where the defense just for me personally loses me. I know folks can agree or disagree. We've got all kinds of opinions in the chat. So that's, zero disrespect to anybody who disagrees with me. I love the fact that people are bringing different perspectives from different experiences and whatnot.
Also, if James had violated any laws as it relates to storage, specifically gun storage, you would have heard about that, but you didn't. In fact, you heard from ATF agent Brandon, who told you there are multiple ways to store a firearm. Multiple ways. You can use a safe. You can use a cable lock. You can use a trigger lock. You can store it unloaded with the ammo separately. You can store a firearm in any number of ways. That came from ATF agent Brandon.
Yeah, but the problem here is that he didn't use any of those for the 6 hour. I just, and again, zero disrespect to this attorney for making this argument, because it's factually accurate what she's saying here, right? That yes, ATF Special Agent Brett Brandon did testify to that. He said there are multiple ways of locking up a firearm, But he disagreed with her on that one point that she was like, well, you can also just have a gun laying out. I mean, she did say laying out, but like that was her implication, was like, you just have a gun sitting there, and so long as there's no ammunition in it, it's perfectly safe, right? There's nothing dangerous about it. And he was like, no, I'm not going to agree with you on that. So again, zero disrespect to her, but there's just parts that are easily rebuttable.
Those were his words. If the prosecution had evidence that James knew that his son was accessing firearms without his permission, not that his son was accessing them without his permission, that James knew that his son was accessing them without his permission, the prosecution would have shown you that. But you didn't see it because it isn't true. James didn't know. This can be your reasonable doubt. Mr. Wagrowski testified that James would have heard his son handling the firearm, the Kel-Tec that you saw the video of, where he sets the Kel-Tec on the table and loads the magazine. He slides the slide forward. He releases the slide forward. Mr. Wagrowski testified from this chair that James would have heard that because of the volume of the sound and because of the size of the home. You all have observed James throughout this trial. You've seen him. Judge Matthews instructed you at the beginning, James is wearing headphones. James is hard of hearing. He needs a hearing-assisted device to hear, even in this courtroom. And if you watched, there were points where he had to push the headphones into his ears so he could hear better because he still couldn't hear well enough.
So I was going to answer this at one point. Oh, I totally was going to answer questions before the defense closing. I'm so sorry, guys. But Chip sweating him. Why is he wearing headphones? There's your answer.
Your Honor, I hate objecting in a closing, but that is not evidence, and her client didn't testify, and so it's just not evidence what he was doing, and it's just not. And his headphones are not evidence.
There's evidence that he needs a hearing device, as I explained to you in the beginning of the trial why he was wearing those headphones. Go ahead.
Thank you.
It is, I will say, I haven't talked about this with this trial, but it is a little bit frustrating that the judge doesn't state her rulings on the record, whether she is sustaining or overruling an objection. She was overruling the objection by clarifying to the jury about the headphones. See, this is one of those things people sometimes ask about closing arguments. Can you object to the other side doing their closing argument? Yes, you can. You've got to be careful though, because it can backfire. Now, the state did object in a way that came across as respectful and professional, thank goodness, but she ended up being actually incorrect, because even though technically it wasn't evidence, it was an instruction that the judge did give. So that is something that was basically undisputed by both sides. So the judge saw that as something that both sides agreed that they were not going to fight about, and so therefore it was just a preliminary instruction.
Thank you, Your Honor. Mr. Wagrowski also testified that he could not indicate and could not say with certainty where James was at the time that his son made that video. He knew that James was likely at the home. He didn't know if he was outside in the very large backyard that Detective Stoyek told you about. He didn't know if he was in the home. He didn't know if he was standing next to him. He didn't know if he was standing outside. He didn't know if he was in another room. He didn't know if he was sleeping. Mr. Wagrowski couldn't tell you what was going on other than James Crumbley's son handling that firearm. Was it unsupervised? We don't know. Was it supervised? We don't know. We don't know. So any statement by Mr. Wagrowski that James had to have heard that is an assumption. It's not based on fact, and it's not based on evidence. If the prosecution had evidence that James was concerned about his son's mental stability, or if his son had asked him for mental health treatment and it was denied by James, you would have seen that. Not a statement by his son to a friend or a writing in a journal, a statement by James that he acknowledges that his son was having issues, that his son was having a hard time, that his son needed help. None of you saw that. None of you saw that because it's not true. James had no idea that his son was having a hard time.
Oh, okay. I mean, that's a decent argument. But I don't think that you can say that definitively absence of evidence doesn't equate evidence of absence. But I mean, I don't blame her for making the argument. Mountain Princess 207, thank you so much for gifting five more Legalbytes memberships. Caitlin Moore, Gamer Ducko, Michael J Money, Sarah, Angela, Eric Newman, Samwise Ganja, you have all been gifted memberships by Mountain Princess 207. So, thank you again, Mountain Princess. Very kind and generous. And also, Shireen, welcome back to Bite Club. I know you were trying to re-up your membership. Okay.
Instead, you saw text between James's son and his friend in April of 2021, where his son says he's going to tell his parents about the issues he's having. You also heard testimony from James's sister, who said she saw him within a day or two, maybe 3 days, of those texts being sent to his friend in Florida after their mother passed away. James and his sister's mother passed away. She spent a week or a week and a half and saw James and his son, and saw no concerns, not worried, didn't hear anything, didn't see anything, wasn't made aware of anything, no concerns. You heard that on November 30th of 2021, James drove his son to school. You saw the video of James dropping his son off. You heard that later when James went to the school with his wife to meet with his son and the school counselor, Sean Hopkins, and the dean of students, Nick Ejak, that James had told them, or that James had had a conversation that he had talked to his son that morning, told his son he loved him. We just want you to do your schoolwork. We want you to do your best. There was never a conversation about, Dad, I'm having a really hard time. Dad, I really need some help. In fact, there were no concerns expressed whatsoever. James had no knowledge that there was an issue. You also heard Sean Hopkins and Nick Ejak both testify that in the office, sitting in the office, that James sat next to his son, right in front of Sean Hopkins' desk, sat next to him, went over the piece of the math assignment with him, the drawings, what was on there, that he was caring, that he told his son, you can talk to me. You can talk to other people. There was some reference to a journal. There was no indication that James knew what the journal looked like, whether or not his son was even writing in a journal, where it was, how often he used it. No indication at all. Just
Okay, hang on.
that one may exist.
Well, but I mean, the other part of that statement was he also said, and you and I talk. I understand why she doesn't want to highlight that in this particular moment, because she literally just said Ethan never told him, or the shooter never told him, his son never told him about these things that he was going through. There's no evidence of that. Well, there's no digital evidence of that. But it sounds like there's a reference to father and son talking about hard things. And so maybe there were conversations that just have no receipts because they were in person. I don't know.
And again, in that meeting, there were no comments, whether either before James got there or after he arrived, from James's son to the school counselor or the dean of students saying, I really want some help. I'm really having a hard time. I really need to see someone. I've been trying to talk to my parents and they haven't been listening to me, and I need you to tell them. That didn't happen. Instead, Mr. Hopkins testified that he had concerns about the level of although appropriate, the level of sadness that James's son was experiencing. Sadness associated with the losses that he'd had that year. He lost his grandmother. He lost their Great Pyrenees dog. His friend moved away. He had a hard time with COVID. He struggled with virtual school. Mr. Hopkins was concerned about the sadness and wanted James's son to see someone to ensure that it didn't get any worse. Not that he had to see someone right now. It's an emergency. He has to see someone right now. That's not what was said. In fact, if you recall Mr. Hopkins' testimony, and I believe Mr. Ejak said the same thing, that James and his wife were told that the school was going to follow up with them within 48 hours. Now, in Mr. Hopkins' head, he testified he was thinking it was going to be the next morning, but he told them 48 hours. You heard Mr. Hopkins testify that James's son said he wanted to stay in school. In fact, he even asked for his homework while sitting in the office waiting for his parents. He asked for them to go get his homework. So they went and got his backpack. They brought it back. He started working on schoolwork. His attendance wasn't bad. There's some question about whether or not he missed one or more days of school that year, but his attendance wasn't bad. His grades weren't terrible. They were average, according to Sean Hopkins. There were no concerns, even by Sean Hopkins and Nick Ejak, beyond the sadness that they saw James's son was experiencing. The absence of evidence that James knew about the struggles that his son was having can be your reasonable doubt. You heard from James himself more than once. You heard him tell the police that there weren't any issues with his son. Within an hour of the shooting at Oxford High School, James was at the police station with his wife, interviewing with law enforcement, talking to them, saying, my son was a great kid. I think he used the word perfect. That his grades were mediocre, again, although Sean Hopkins said they were average. But that he'd never had any disciplinary issues. Sean Hopkins and Nick Ejak confirmed that. They had no disciplinary history with James's son. And even if you have a question about how great of a kid James thought his son was, Christy Gibson Marshall said the same thing to you. We'll talk a little bit more about that. But Christy Gibson Marshall also said that James's son was a good kid. Christy said that her testimony was that she was standing in the hallway. She had spotted the shooter coming down the hall with a firearm, with a gun in his hand. She saw that there was an injured student in the hallway. She walked up to the student, was standing next to it. You saw the video. She's standing next to the student who's injured on the floor. The shooter gets closer and she realizes that it's James's son. And her first thought was that it couldn't be right. With a gun in his hand and an injured student in front of her, smelling cap gun, she didn't think that was right. Even in those moments. Going back to Sean Hopkins and Nick Ejak, two people who met with and talked to James's son on November 30th of 2021, at one point for over an hour without James and his wife there. They talked about a variety of topics. This was 2 hours before the shooting began. They said that based on the explanations that they were given about the drawings on the math assignment, that they weren't concerned. Kids draw violent things. Kids draw guns and bullets. That the confirmation combined with the confirmation from James and his wife about what was going on in their son's life, in combination with the explanations that they were given by James and his wife's son, that they weren't concerned. There was an explanation about interest in video game design. They looked a little bit about video game design. Sean Hopkins and Nick Ejak weren't concerned on November 30th of 2021, 2 hours before the shooting started. Both Sean Hopkins and Nick Ejak told you that guns are not uncommon in homes in Oxford. It's a hunting community. That it's not uncommon for students to handle guns in their homes or to go to the shooting range. That they knew that James's son had gone to the shooting range the weekend before with his mom and that he had access to a firearm. They didn't ask any more about this, about access to a firearm or having a firearm in the home, because they weren't concerned that James's son was a danger to anyone. They weren't concerned. Sean Hopkins and Nick Ejak testified that they had concerns related to the effects of the losses that James's son had experienced in that year. There was testimony that James's son's level of sadness was appropriate given various factors, but that it wasn't concerning. They just wanted to address it to ensure it didn't get any worse, because they'd seen sadness get worse and have issues with other students, according to Sean Hopkins' testimony. We talked about Sean Hopkins and what he said about wanting James's son to see someone within 48 hours. You also heard testimony from Sean Hopkins and Nick Ejak that they didn't believe that, or they believed that James and his wife were going to get their son help, that they had no reason to believe that they weren't going to. And if they did, they would have done things differently. If they had concerns that it had to happen right now, they would have done things differently. But they didn't. Sean Hopkins and Nick Ejak testified that they didn't ask if there were guns in the home. They didn't ask because they weren't concerned that James's son was a danger to anyone. Despite the information and the concerns that they had, they made decisions with the information that they had at the time and based on their education and training, which we can all probably agree, a school counselor and a dean of students has more education and training than the average parent. And even with all of that and the experience with teenagers and what they had in front of him, they still didn't believe that there was a reason to be concerned that James's son was a danger to anyone. In fact, they didn't even feel that he was in immediate danger to himself, because if they had, they testified, they would have done things differently. James worked. You heard the testimony. He left the school at approximately 10:57, and if you want, you can go back to the exhibits, and logged on to the app for DoorDash and started working within 3 minutes. The prosecution is focusing on James not going home in the time from leaving the school and when the shooting started. Why would he? He didn't know. He didn't know what was going on with his son. He didn't know what his son was planning. He didn't know that his son knew where the guns were. And he didn't know that his son had somehow obtained access to those guns or a gun. He didn't know. So why would he go home? There was no reason to. You heard about James's actions following learning of the school shooting, or following the school shooting. You heard that he went to the Meijer, which was the reunification point on Ray Road. You heard that he saw the police lights. He saw multiple police cars. He followed them. He actually tried to go to the high school first, and he couldn't, so he went to the Meijer. And it was there that he learned that there was a shooting at the school, that there was an active shooter at the school. There's evidence and exhibits showing James's movements while at the Meijer. He was there for approximately 6 to 7 minutes. In that time, he texted his son. You can see that on exhibit 375. He called his son to see if his son was okay. He texted his son again. He called his wife. He talked to his wife for about a minute, and he left the school. Then he called his son 2 more times. 2 more times in less than a minute to find out if his son was okay. He talked to his wife again for about 10 minutes. You saw a text during that phone call from James's wife to one of her coworkers where she says that their son was the school shooter. Contrary to Detective Lieutenant Willis's testimony that James said his son was the school shooter, he didn't. James didn't say that. You heard the 911 call a few minutes ago. That's not what James said. James called 911 at 1:34 p.m. and said that his son was a student at Oxford High School, and that after he'd learned about the school shooting, that James had gone home. He found the gun and bullets missing. He didn't know if his son took it, that he didn't know if it was him. And if you recall, Nick Ejak and Sean Hopkins both testified that even during the shooting at the school, even after the meeting that morning with James's son and James and his wife, even in those moments, they did not suspect that James's son was the school shooter. Sean Hopkins testified that he didn't even think that it was James's son who was the school shooter until after he checked attendance, after the shooting had ended, and after James's son had been arrested. You heard James say on the 911 call that he was really freaking out. You've heard that a couple of times from James. And you can listen to that call yourself. It's Exhibit 154. You can almost hear, as James is talking to the dispatcher, how he's looking back at what had happened that morning and trying to piece things together and figure out what's going on. You heard from James 2 more times within hours of the shooting at Oxford High School, once at the substation and once while in the backseat of a patrol car. At the substation, James learned that his son was the school shooter, that he was not injured or anything, that he was in fact the school shooter. You heard James say he was freaking out. He asked for a water. His mouth was dry. He was freaking out. James was emotional. I believe that Detective Sergeant Bryan testified that James was sobbing, that he was crying. You can watch it. You can see how James was reacting in that interview. Detective Bryan said that James was forthcoming, that he was willing to speak with them, even after James's wife suggested, maybe we should get a lawyer. Maybe we should stop talking. James said, no. Let's keep talking. I want to keep talking. It's okay. We can keep talking. And he does. He told the police how many guns were in the home, where they were located, that the handgun that was used by James's son in the shooting was a 9mm Sig Sauer. He mispronounced it. We've all heard that. That it was hidden in an armoire. No one in that interview, neither of those 2 law enforcement officers in that interview said, well, you shouldn't have had it there. Was it locked? How did your son get it? You didn't hear those questions. You heard James.
Okay, but that doesn't really help the defense case, in my opinion, because the truth is it wasn't locked. Because we know because of the search warrant, right? I mean that would have been something that would have come up. She would have asked it on cross-examination.
James tell the police that the handgun was stored unloaded and that the ammunition was stored somewhere else. It was stored separately under some jeans. Again, those 2 officers didn't say, well, you shouldn't have done that. That wasn't right. Well, you did that the wrong way. Well, that was really irresponsible of you, Mr. Crumbley. They didn't ask that. They didn't say any of that. The police didn't ask if the gun was locked or in a safe. James clearly told them that 9mm was hidden. And the police moved on. James talked about what a great kid his son was, about his mediocre grades, but overall he didn't get in any trouble. You watched as James saw his son for the first time after that school shooting. It was a very brief encounter. And you saw as James was leaving that he repeatedly told his son he loved him. Ladies and gentlemen, you can watch that for yourself. It is Exhibit 301. He repeatedly told his son he loved him. And then after, as he walks back into the first interview room, you can hear him audibly crying, sobbing at what was going on. And what does he say? He asks the police if he can find out where his son is going to be. And they say, yes, the court will tell you. In that interview, you also heard James Crumbley say, I wish we had taken him home. In hindsight, looking back, I wish we had taken him home. James had no knowledge that his son had access to any of the handguns in the home. You saw his son's own words sometime after November 27th of 2021 and before November 30th of 2021. And we know that because in Exhibit 359 on page 22, his son specifically writes 9mm. And we know that there was no 9mm in that home prior to November 26th of 2021. We know that James's son went to the shooting range on November 27th of 2021 with his mom. So we know that had to have been written sometime between November 27th and November 30th of 2021. We talked quite a bit about this during jury selection. Most, if not all of you, agreed that there's a difference between having access and giving access. We talked about car examples. We talked about the responsibility in different scenarios, a parent's responsibility in different scenarios. This case is like the first car scenario, where the child takes the car without the parents knowing, takes it out and something happens. This is the first scenario. This isn't the second scenario where the parents might have suspected that their child might do something. This wasn't the third scenario where James knew his son was going to do something and just handed him whatever it was he was going to do it with and said, here, take it. This is the first scenario where James Crumbley had no idea what his son was capable of. He had no idea what his son was planning. And he had absolutely no idea that his son had access to those firearms. Also, as an aside, if it really were his son's gun, why was it hidden in James's bedroom? If it really were.
But then why wasn't it hidden in a gun safe like the other two were?
Why was it hidden?
Locked away in a gun safe is what I mean.
Not only in the bedroom, but in a location that James's son was not aware of. Sometime before November 26th of 2021, James's son wrote this in that journal notebook that was found. Exhibit 359, page 15. We know that it was before November 26th of 2021 because of some of the other statements that are around that journal entry, which you can look at if you'd like, but they reference a 9mm and a .22 caliber. And we know that there was not a 9mm in the house before November 26th of 2021. And even here, I don't know where my dad hid it, is a reference to .22 Cal-Tech. Even before November 26th of 2021, well before November 30th of 2021, James Crumbley's son didn't know where those firearms were. He told you he didn't, in his own words, in his own handwriting, which was verified by law enforcement. There's no evidence that James Crumbley had reason to believe his son would hurt anybody. I went over this a few minutes ago. Christy Gibson Marshall's testimony was that she had known James Crumbley and his son since approximately 4th grade. She told a story about James emailing her and asking about getting his son's report card or grades or something along those lines. And she responded and said, give him a hug for me. She testified about everything she saw, heard, and felt on November 30th of 2021. And as I said, she talked about seeing the shooter walking toward her with a gun in their hand. That as the shooter got closer, she recognized that it was James's son. And in those moments, she thought to herself, this can't be right. He's always been such a sweet kid. She was in such disbelief that was his son that she even tried to talk to him. As he's walking through the school with a firearm in his hand, she is trying to talk to him because she just can't believe that James's son was the shooter. And it was when he wouldn't respond that she realized it must be him. ATF agent Brandon testified there were no laws governing the storage of firearms. We went over this a little while ago. We talked about the various ways that you can store firearms. I outlined a few of them. He testified that people store firearms unloaded and unlocked, which in and of itself is not irresponsible or dangerous in 2021. Not putting a gun in a safe or using a trigger lock alone does not mean that that person is irresponsible. Now, ATF agent Brandon gave you his opinion about what he saw on that math homework. That opinion was given within the last couple of days. And with all due respect to Agent Brandon, his opinion on what he saw is irrelevant. It doesn't matter in this case. What matters in this case is what people thought that math homework showed on November 30th of 2021. And those people weren't concerned. They didn't see what Agent Brandon saw. They saw images that weren't concerning, that are common, that other kids write and draw about. The concern was that he was sad and needed to talk to someone.
Well, I mean, because that's the thing, right? It's like she's trying to separate these things, the images that other kids do too. But then she says, and he's also sad. In context, it's all together, right? Like it's you can't put these two things into a vacuum. He was sad and he was drawing these things and writing these things on his math assignment that everybody saw, right? You can't just like only look at one, like, close one eye and look at it and then close the other eye and look at it and be like, oh, they're two different images. You can't do that. So, I again, like I respect her for her argument. I'm just disagreeing here.
On November 26th of 2021, we saw evidence and her testimony that James Crumbley went and bought the Sig Sauer at the gun store. James had been to that gun store on multiple occasions. We heard that testimony from Miss Back, who told you that she recognized him because he'd been there before. There were at least 2 other handgun purchases from that store, which we heard about, the .22 Derringer and the .22 Kel-Tec. James indicated, per Miss Back, that he'd been looking at the Sig Sauer for a few days or a while. She couldn't really remember which one it was. She testified to both. That he knew that that was the one he wanted to purchase. So he did. You also heard Agent Brandon testify about the cable lock that was found in that Sig Sauer gun case. That the sleeve that the cable lock came in was essentially in pristine condition, that the keys were still inside the lock. Now, if you recall, that Sig Sauer was used. James bought that used. That sleeve being in pristine condition means that the person before him didn't use it either. You also heard that James did not purchase ammunition on November 26th of 2021 or at any point prior to November 30th of 2021 for that 9mm. There were purchases for ammunition when he would go to the gun range for the .22s.
Well, that's why I didn't buy it
James
then.
didn't purchase
He already had
9mm
it.
ammunition before November 30th of 2021. Tammy Back told you that she had, that James didn't even talk to his son while they were standing there in the gun store. She didn't see any of that. She had no reason to believe that James was buying that gun for anyone but himself. And if she had, she couldn't have sold it. So obviously she didn't think that. On November 3rd of 2021, James Crumbley and his wife left a hotel that they had been staying in. Well, they had stayed in a couple different hotels, but they left a hotel that they had stayed in after the shooting on November 30th. You heard some testimony, or you heard some information that their residence had been made public, or there was media there, or there were things going on. And you can imagine, I mean, you all can imagine what that was like in the days following the shooting at Oxford High School. You heard Agent Brandon testify today that James and his wife were in and out of that building throughout the day on December 3rd of 2021. You heard testimony yesterday from Detective Willis that they arrived at approximately 11 a.m. and that they were there for the day. They were obviously arrested later that night. But you heard testimony that Luke Kirtley saw at least James Crumbley. You heard that James and Jennifer had both gone in and out of the building. Jennifer is his wife, had both gone in and out of the building throughout the day, various times to smoke, walk out to the car. Sometimes one of them went, sometimes both of them went. December 3rd, 2021 was a Friday. It was a work day. They were in and out. You heard that there were at least 14 cigarette butts found near their vehicle. You saw over 300 exhibits during this trial. You heard testimony from over a dozen witnesses. None of them told you that James knew what his son was planning. None of them told you that James knew that his son was a danger to anyone. None of them told you that James knew that his son knew where those firearms were hidden. None of them told you that James knew that his son had somehow obtained access to the firearms that he had been hiding. None of them told you that. Because on November 30th of 2021, James Crumbley had no knowledge about any of that. He had no knowledge, and he had no reason to suspect what his son was planning to do later that morning on November 30th of 2021. Now, every time I do a trial, I have somebody tell me that they think of a reasonable doubt that I may not have thought of. So think of your own. You don't have to agree with all of mine. You don't have to agree with any of mine. You can come up with your own reasonable doubt based on the evidence that you've seen, the testimony that you've heard, your collective memories. You can come up with your own. You're not limited to what I've come up with, and you can certainly reach your own reasonable doubt conclusions on your own. And as you deliberate, think about the things you did not hear during this trial. Think about the things that you were told you would hear during the opening statements, that you would hear how the shooter gained access to that gun. You didn't hear that. That you will hear from school officials regarding their concerns about the math worksheet. You heard that they were concerned about sadness, not about danger to others. That you will hear that the need for immediate parental intervention was necessary. You didn't hear that. In fact, you heard the opposite. You heard that Sean Hopkins said that James and his wife, that they wanted James and his wife to have their son talk to someone or to at least make arrangements within 48 hours. No one testified that immediate parental intervention was necessary on November 30th of 2021 during the meeting with Sean Hopkins and Nick Ejak. No one testified that there was a need for immediate intervention of any kind, discipline, mental health, or otherwise. You did not hear testimony detailing how the shooter obtained access to the 6 hour. You just saw in his journal that he said he had access, but you don't know how that happened.
Well, we also heard descriptions by the defendant of how he stored that weapon, and none of that was secure.
No one testified that the shooter knew that there was any sort of code to open the gun safe. There's been some talk about the code that was used on the gun safe with the Keltec and the 6 hour. There was no testimony that the shooter even knew about that code or what it was. You did not hear any mutual concern for the shooter's well-being from his best friend's dad, who you saw text with between James and his friend's dad, who obviously has experience with mental health with his own child, from what you can see in the texts. And even that man didn't express any concern for James's son. In fact, on November 30th of 2021, he texted James, said, "I hope everyone's okay." No one told you that James Crumbley was aware of the texts or videos that were sent to his son's friend. In fact, they all testified, all of the witnesses testified they couldn't tell you that. They couldn't tell you that he was aware. You don't know if the shooter ever actually did do what he told his friend he was going to do. He was going to tell his parents about this, that, and the other. You heard no evidence that he actually did. You heard no evidence that he actually told James any of that. And when you go back for deliberations, think about everything that James Crumbley did not know. He did not know he had to protect others from his son. He did not know he wasn't exercising ordinary care in the way he was storing his firearm because he didn't know that his son was planning what he was planning. He did not know that it was reasonably foreseeable that his son would commit these offenses. He had taught his son firearm safety. He had taught his son to be familiar with those firearms because they were in the house. He had no idea what his son was planning to do. In fact, no one that interacted with James Crumbley's son on November 30th of 2021 knew what was going to happen a short time later. No one. And this is the part of the trial that I dislike the most. The prosecution gets to stand up and make a rebuttal statement, and I have to sit down and I don't get an opportunity to respond. That's how trial rules work. The court has told you that. That's just how it works. But the hard part for me is that every time I hear a rebuttal from the prosecution, I think of all these things that I want to say. think of all these responses that I can give. So what I'm going to ask you to do, we've gotten to know each other over the last couple of weeks. You've seen how I am in court. You've heard the questions that I ask. So when you go back to deliberate, think to yourselves, what would Marielle say? What would she say about this? What would she say about that? Because unfortunately, I can't tell you. I join with the prosecution in thanking you all for the time and attention that you've paid to this case. You have heard some of the most emotional testimony and seen some of the most difficult things that I can imagine a juror could see. And you likely may not be able to forget it. But what you're all doing in these chairs is of the utmost importance. And I thank you for the time and attention that you've paid. Early on in this case, during our opening statements, the prosecution and I both asked you to follow the law. And I'm going to ask you again, follow the law. The judge will instruct you on what the law is. She will give you very clear instructions. Please follow the law. Review the evidence, review the instructions, and follow the law. Because I'm confident that if you do that, each of you will have at least one reasonable doubt, and your vote will be not guilty. And your vote should be not guilty, not just because you have reasonable doubts, but because James Crumbley is not guilty. Thank you.
Thank you, Ms. Lehman.
All right.
Rebuttal, prosecutor.
State's rebuttal. Oh, sorry. Let me go back. Thought I'd
You know
skip
what
ahead.
my least favorite part of the trial is?
Ooh.
It isn't listening to the defense argue that her client is not guilty. She has a right to do that. It isn't even listening to what I believe, and I'm going to tell you what I think is inaccurate. My least favorite part of the trial is that even when we're standing here and our criminal justice system provides for justice for victims, and my job is to advocate for them, and I'm standing up here and I'm doing that. I've been doing that all week and several weeks before, and I'll keep doing it. You know what my least favorite part is? It doesn't take away any of the suffering. It doesn't take it away. So don't deliver a verdict thinking that it will, because it doesn't. Your job is to follow the law and use your common sense when you consider the evidence. I embrace the high burden of beyond a reasonable doubt. I believe in it.
Yeah, I don't know that initial line that she just said on rebuttal that maybe plays well, maybe doesn't. I don't know. I'm of two minds of it. I don't really like the whole personal thing of like, this is what I hate about trial and this is what I hate about trial. But, I will say the defense did give her an opening to walk through that door and say, well, here's what I hate. I hate the fact that people have suffered and there's no way to bring them back, Okay. Yeah. All right.
Wholeheartedly. Devoted my whole life to it. I embrace it. It's what we use for every prosecution in this country every single day of every year for decades and decades and decades. That's the burden we have. And it is not, despite what the argument is always, any possible doubt. You have to be 100% sure. If you're 100% sure, we probably don't need criminal trials. And you can't be. We can't be. That doesn't make any sense, does it? We can't get inside the head of people who commit violent crimes or any crime and decide what they knew and what they wanted and if they loved their kid. I hope he did. I hope he does, by the way. I assume he does. We all do. We all love our kids. That's not my job. It's not my burden.
So yeah, she's not wrong in saying, we don't have to get it to 100%. That's true, right? Because you can have doubt as long as it's not reasonable doubt. The problem is when a juror decides that they have doubts that they think are important enough, usually they're going to think it's reasonable. So, but it's we're kind of splitting hairs there on that point. But, technically she is correct.
So I embrace my burden, but I'm not going to embrace something that's just not true. Because it is not true that I have to prove, and the people of the state of Michigan have to prove, what James Crumbley knew. It is not true that the people of the state of Michigan have to prove that he knew his son was going to kill somebody. We've talked about this before. If that were the case, he'd be charged with murder. That's not my burden. That is not what I have to prove. The judge is going to instruct you what burden. It's a reasonable burden, and it's as to the elements that I have to prove. Only the elements. Beyond a reasonable doubt, using your common sense and your reason. The elements, and what are the elements? You're not going to hear that the elements of this crime are that I have to prove what he knew, what he actually knew. That's not the law, ladies and gentlemen. That is not the law. The law.
Okay. I don't love the fact that she keeps using I, me, because it's just, this is not about her. And she's technically correct. She doesn't have to prove that, right? She is representing the state. She is a prosecutor, but it's starting to feel a little personal, and I don't know. It's just, it gives a little bit of a weird vibe. I'm not going to lie. I wish that she would say, well, hey, the state does not need to prove that he knew that this was going to happen. The state can also get you there by going with X, Y, and Z. So it's just depersonalize it in this rebuttal. That's what I'm thinking. Like, just depersonalize it. It makes it sound less, I don't know, petty, maybe. It's a strong case, but I'm not loving this rebuttal so far.
The law is I have to prove beyond a reasonable doubt what a reasonable person would do using ordinary care. That's what I have to prove.
Don't say I. That's what needs to be proven in this case. That's what the state needs to prove. That's what you need to be convinced of. It's just I don't love it.
There's a couple things I have to correct. The questions defense counsel asks witnesses are not evidence. It's the answers that are evidence, and you have to decide whether that's credible. But Special Agent Brandon did not testify that it was safe. He would call that secure if an unloaded gun was stored separately. In fact, that's not what he testified. What he testified to was that it wasn't storing the firearm or ammunition wouldn't make it secure if you had a 15-year-old who knew how to load and shoot that gun.
Here's what I would have loved to see in this rebuttal here is defense in their closing argument said that the ATF special agent agreed that there are multiple ways of locking the gun. Multiple ways of locking a gun. There are, like, you could totally use this to walk all over the defense, right? You could just say, and guess what? We agree. There are so many ways of locking the gun, and they're very simple ways of locking the gun. You could use a gun lock. You could use a trigger lock. You could use, you could use a gun safe. You could actually change the code from the default mode of that gun safe. These are all things that could be done. Guess how many of those things the defendant did? None. Zero. None of those. The one thing that she tried to get that ATF agent to agree with her that was a safe way to store a firearm, he disagreed with her because this is what he said. And guess what? That's the truth. This is just a way of being able to to, you know, use the firepower from the other side and then just like turn it in a different direction so it actually benefits you. I kind of wish that she had done that instead of what she's doing here.
That was his testimony. You did not hear from people at the school that they were not concerned. That was not the testimony. You did not hear that James Crumbley went home because he was trying to check on his son and he was worried. None of that happened. You heard the 911 call. You have to rely on what you heard, not the questions that were asked. Defense counsel put up a statement from the Journal about my gun and where my dad hid it. And she's urging you to find that credible. But if you do, and we argue you should find, it's all credible. You don't get to pick one statement from a journal and say he was telling the truth there. But all the stuff about how he asked his dad for help, that wasn't the truth. You have to use common sense. And I'm not going to go through every single thing that Ms. Lehman told you, because I know that you were all taking notes and you all listened to it. And I laid out, and I know you remember the testimony. But the one thing I'm just going to ask you one more time is, I embrace my burden, but you have to hold me to the law and what I actually have to prove and what the judge tells you I have to prove.
Again, it's too
Which comes
personal.
down to common sense and reasonableness. Let's step back. We have a person, we have a father who purchased a gun as a gift. He knows he has it. He knows how to use it. He knows he's in the house by himself after it's purchased. He gets called to the school. And the words on the paper, the drawing on the paper is of that gun. You heard Special Agent Brandon. The testimony speaks for itself, and so does the drawing. He saw the words, blood everywhere. He saw the image on the paper with the bullets and the person bleeding. He understands exactly, because the image is there and you saw it, that's exactly where those bullets landed. The thoughts won't stop. Help me. I want help, but my parents don't listen to me, so I can't get any help. And then that day, just hours before, help me. Use common sense. It doesn't make any sense to stand here and say someone had no idea that he needed help when he saw on the page, help me. It doesn't make any sense, because any reasonable person, which is the standard you have to use, using ordinary care, would know that, because it actually says, help me. The world is dead. My life is useless. Those messages you saw, that's exactly what he thought. We know what was going on because of the messages in this journal. And then we know there was a cable lock. You did not hear any testimony about who owned that gun and whether that lock was used or another lock was used. But you do know that whoever purchased that gun had to be 21 years old. You do know that. We've been telling you since this case started, it would take tragically small things to make this.
Here it goes. Tragically
prevent
small.
these deaths.
Tragically small. That
And you're
theme
hearing
again.
a lot about how to store a weapon. And the truth is, this has nothing to do with a safe storage lock. And you don't have to lock a weapon up to make it secure. There's lots of ways to make it secure. But what isn't secure is leaving it around, which we know he did with his other weapon. Leaving it around, my dad left it out, LOL. I thought, why not? Loaded, knowing that your ammo is right there. We know that is not secure. But let's talk about one of the ways that we can prevent access to minors. This is the murder weapon. This is the gun. We know we presented evidence of this. I'm going to put it right on the table. This is a cable lock. This little piece of cord. This is me inserting the cable lock. We know that a cable lock was in the home. We know it was provided. This is me inserting a cable lock. That takes less than 10 seconds. Takes less than 10 seconds. 10 seconds. You don't have to go find it. You don't have to go buy it. It was provided. It was right there. You just watched me do it. 10 seconds of the easiest, simplest thing. One of which, by the way, not the only way. Locking was not the only way to prevent this, but it was one way, and it took less than 10 seconds. Let's talk about the gun being hidden. Let's talk about that. You heard the defendant's sister say, yeah, he went and got the gun from his bedroom. These are the other two guns. Ladies and gentlemen, the guns were kept in the bedroom. The family was there when she was told that, and everyone knew the guns were kept in the bedroom. This is where he says he hid the gun, the armoire. This is what it looked like that day. Wet towels folded over it. It wasn't even closed. He says it was in the armoire under some jeans. This is not hiding a weapon. This is just where you kept it. It is not reasonable to conclude that a 15-year-old who spends all kinds of time in the house alone would not know where it was, because it wasn't hidden. This isn't a case where we have a parent who hides a weapon far out of reach from a child who couldn't get to it, doesn't know it exists, ammunition in a totally separate spot. The kid, that's not this case. It's reason and common sense is what we have to use. We know that James Crumbley went home and looked for a gun when he heard there was an active shooter. And we know he referenced there was that meeting at the school. That's foreseeability. And that's a person who suspects their own son. And that is what I have to prove. Foreseeability to an ordinary, a reasonable person using ordinary care. This case is not a statement about guns. It's not a statement about parental responsibility. It's not about kids doing kids things. The kids on November 30th in that building were doing kids things. Hannah, Madison, Tate, Justin, they were going to class. They were talking to their friends. They were dancing in the hallway. Those are kid things. Parenting is the hardest job that we'll ever do. The hardest job, and one of the most important ones, but it's exhilarating and joyful and the best experience of our lives. We look at our kids when they're born and we see hope. But they can break your heart. They're supposed to. They have to leave someday. They don't come with a set of instructions. I'm not here to tell you that this case is about somebody who didn't follow the instructions to be a perfect parent. But we do have a guide. We do have a basic standard for ordinary care. We all have doubts about our kids. We all worry every minute of every day that they're going to do something or something's going to happen to them, and then it might be because of something we did or we didn't do. We are not responsible for everything our kids do. This prosecution in this case is not inconsistent with that. It just isn't. This is a very egregious and rare set of facts. We do have a measuring stick, ladies and gentlemen, and it's the law. And it requires us to use ordinary care. And there is a consequence if we don't, in a very limited way that the law allows a parent to be charged. Your job now is to go back there and use your reason and common sense and follow the law. That's what your job is. You listen to all the evidence, and at the end, you will conclude that James Crumbley failed. He might love his kid, I hope he does. But stick to what I have to prove. Stick to what I have to prove. And remember that he didn't just fail in his duty to his son. He failed in his duty to protect Hannah and Justin and Madison and Tate. And I don't say their names to evoke sympathy. I say their names because they matter. They matter. And that is why we are here. We are absolutely here about what happened in that school that day, because if James Crumbley had done even the smallest of things, like the 10-second cable lock, or gone home, or took responsibility for his kid who was in trouble, those kids wouldn't have been shot and killed in that school on that day. I have met my burden. Mr. Keese and I, the people of the state of Michigan, have met the burden to find James Crumbley guilty of 4 counts of involuntary manslaughter. And I ask you to return that verdict. Thank you.
Thank you, prosecutor. I'm now going to read jury instructions to you. Does anybody need a break before I do that?
Yes, I need a break. Well, actually, so we are not going to go through the jury instructions. If you guys want to, I mean, it's on YouTube. I just don't have time for it today. Let me get the questions that I've been saving here so that we can get through those, and then we will wrap it up. Okay. Let's see here. Sarah says, question, what did you think of the prosecutor saying that the defense talked about a car or a sharp object is the same? That was the lawyer in Jennifer's case. Is that allowed or bad when it wasn't this lawyer? I can't remember if this attorney mentioned it in her opening statement. I don't remember that. Yeah, she may have mixed up the 2 trials, but there wasn't an objection from the other side. So, yeah, I'm not too worried about that one, I guess. Let's see here. Shireen, what is the sentence for negligence? It's up to 15 years. I don't know if there's a minimum. Debbie Face on Cook, my biggest question is when mom was shown the picture, why didn't she tell the school that she had a gun? Why didn't dad? But why didn't the school ask? Like there's that it's along those same kind of lines. On that point, I blame everyone at that meeting for not saying something or asking something that they should have. Sokotoa, sorry, I already got that one. Sokotoa, did they ever mention if the issues his son had were environmental, hereditary, or chemical? No, they never got into that level of detail. Claire Niam, how expensive is the gun they bought Ethan? I think it was like around $500, I think. So, for people that are supposedly struggling with money, that's a lot. That's a lot to buy something. A culpuristic, if you know your kid is in a gang and they commit a crime, are you now an accessory? If you should have known, that is no different. Can parents now disown children in gangs for fear of being charged? Well, one element to this is also, there's a number of factors at play, right? And part of that is the control that you have over some of those things, right? I'm sure an argument could be made just, pushing back on that, playing devil's advocate on your hypothetical. I think an argument could possibly be made that, a kid who's in a gang might be pressured by peer pressure as part of the environment. it's one of those things like kids kind of get stuck in those things because of the environment that they grow up in, the neighborhood they grow up in, things like that can play an influence. So I think that when there's that kind of stuff that plays a bigger role, there's less control that we can really say that the parent has in that situation. Not saying that I'm 100% going to make that kind of an argument if someone were in that position. I'm just saying hypothetically that's a counter argument that could be made. So, but I do see your point in what you're saying there. Elliot JN question, Alita, can you speak to the relevance of going over the evidence from the warehouse? Would that not be a different charge? Also want to add that not all people who are depressed show it. 100% agree with that statement. Not everyone who is depressed shows it. However, the first point about the evidence at the warehouse, this is just to show bits and pieces of what things looked like when they were staying at a place that wasn't their home. Did it look like they were trying to sort of settle in a place that wasn't home so that they could get away from, criticism, from death threats, from that kind of thing? Or did it look like they were trying to stay mobile, be moving from one place to the next? One thing, and if so, why? Is that because they have people that are still following them with death threats? Or is that because they're worried that the police are following them? So that's, and all of that comes down to evidence of consciousness of guilt. That's why all of that comes in. Matuo, would this prosecutor say this wasn't an issue if the cable lock were used? I don't know. It's hard to say, but it definitely would be a strong argument by the defense to say, look, this is a reasonable way of locking up a gun. And I didn't think that my kid would go so far as to, find some sort of like crazy strong shears to clip through it or, use some other kind of tool or something like that. Like there's a much stronger argument for the defense if a cable lock had been used. So I don't, but would the prosecution still try to make an argument? I don't know. I mean, it depends on this person's style. I don't know. I don't know their previous like charging history to be able to really tell you. Janet G, does Ethan have the ability to appeal and get his sentence changed? So, a little bit of confusion on this point that I wanted to clarify is, the fact that so he did plead guilty to the charges, but what he is trying to appeal is, sorry, and I'm looking at the article that I found here. He's got the state appellate defender's office who is helping him to appeal his sentencing because he was sentenced to life in prison without parole. So that's what he's trying to get changed. So was that just so that he wouldn't have to testify in his parents' trials? Maybe. Could be. Or maybe he's legitimately trying to appeal that sentencing. I don't know. Alex, quick question. Where can I watch recorded court cases? Is it all on YouTube? So YouTube is one place. You can also go to Court TV's website. They've got older trials in full that you can watch. That's what we're doing for our classic trials series on this channel on Mondays, so that we can watch the Menendez brothers trial. I use Court TV as a resource. So that's another place you can go. Daniel Roselle, I'm sorry that this is sort of an unnecessary question, but if a defendant wants to take a break because they have trouble controlling their emotions, are they allowed to call for a temporary recess? So not an unnecessary question at all. I thank you for asking it. So there's usually just about always going to be some kind of instruction on like don't be noisy, don't be don't be really obvious about emotions that you're showing and that kind of thing, because it might be looking like you're trying to put on an act. However, there are times when things are do really have a strong effect on people. So what would happen is, the person, the defendant or whoever could, turn to their attorney and say, like, I'm having a really hard time. I've got to take a break here. Is there any way we can request that? And the attorney would request that, not like, announce one, but would request that from the judge. It would be up to the judge. It kind of depends on really how what the judge is thinking on that. In a lot of cases, I wouldn't be surprised if the judge says, sorry, you got to sit through it and work through it. Sorry, Greg Palmer, does the jury know the verdict of Jennifer Crumbley? No, but they do know that that Jennifer Crumbley has already sort of been looked at, her and Ethan. The state indicated that in their opening statement that they basically they've already had their day in court, kind of, and now it's up to James to have his day in court. Rouse J 1199. If the parents take him home and the next day he kills, do they still get charged? I mean, maybe, right? We've got to look at some other factors there. Is this something that they took him home and they left him at home and then went back to work? Or did they go and spend some time with him and talk with him? Did they go and immediately take him to therapy? Did they go and then also, have a discussion with him and then realize we really should probably lock up our firearms and do that? It depends on what they did in taking him home. If they did and they reasonably tried to make some efforts to help him out, then maybe not. But if they just took him home, dropped him off and went back to work, I don't know. I don't know how much that actually helps. All right. I'm waiting for, okay, here we go, for StreamYard to populate here. Draco Amy live. Is there such a thing as voluntary manslaughter, and what's the difference? Yes, there is. Voluntary manslaughter is when, so one form of voluntary manslaughter is, for example, not everyone here is, maybe familiar with the Menendez brothers trial, right? But in the early 90s, they were on trial for shooting their parents, and they said that they had a reasonable belief that their parents were about to kill them and that this was self-defense. However, one of the lesser included charges for murder was voluntary manslaughter. And basically, if the jury had determined that they had a sincere but unreasonable belief that their parents were about to kill them, then that would be voluntary manslaughter. So that would be one example. Like if somebody has, a sincere but unreasonable belief. So that's in a self-defense case. I would need to look at the specific charges, or the laws of Michigan. Let me see here. What does it say about voluntary manslaughter in Michigan? Okay, hang on. Come on, internet. Work with me. Okay. Well, manslaughter is homicide without the elements of malice and premeditation. So it could also be a killing of passion, like in the heat of the moment where you didn't intend to kill someone, but then you like in the moment got really upset because your significant other cheated on you or something like that. That's another option for voluntary manslaughter. Okay. All right, folks. I think that's all the questions. Thank you so much to the people who bought super chats, to those who bought memberships and bought memberships for other people. Love all of it. Thank you so much to everybody who just watched and liked the video and, engaged in the chat or commented in the comments if you're watching on replay, or if you just lurked. I appreciate all of you nonetheless. So thank you so much, you guys. I need to get moving from here, but this has been a very, very fruitful live stream. I'm going to be continuing to monitor. So far, I see that there hasn't been a verdict. I'm just, let's see here, just making sure. I'm refreshing Twitter, and so far nothing. It's pretty quiet from what I can see here as to what's being reported. So, so yeah, if there is something that comes up and cameras come back to the courtroom, then I anticipate going live. So stay tuned for that as well. All right, folks. I think that's about it. Thank you also to the mods, as always, for helping to make sure that folks agree and disagree, but do so in a way that is constructive. Okay, guys. Thank you. I got to head out. This has been great. I'll see you guys in the next video.